Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item number 23, Your Lordship. This is that whole matter, Your Lordship.
No objection, my lord.
After 4 weeks, Your Lordship.
Yes, 3 weeks.
3 weeks.
As paid for by London Council for the petition. Yes.
May please, Lordship.
Yes.
Lordship, beg to mention item number 25, Your Lordship. I be going to the private respondent also. It's a second the government. Yeah.
I'm appearing on behalf of state respondents.
No objection.
State respondents.
No
sorry.
objection.
No objection.
Private respondent 5.
This also same.
Matter
weeks.
after 2 weeks, Lordship. Yes, Lordship. Deeply obliged, my lord.
Oblige. May I please, Your Lordship? I beg to mention item number 24. I pray that this matter will come after 1 week, Your Lordship.
You're appearing for the
Petitioner.
Mr. 24 is a criminal appeal, isn't it?
Yes,
24 is a criminal appeal.
yes, yes, Your Lordship.
You're appearing for
Broadstar Hujan.
yes. Yes, sir. At the request of the appellant, list of property. Yes, sir.
Only obliged, my lord.
Much.
May please, Your Lordship. I beg to mention item number 21 and 22.
Yes.
In 22, I'm appearing, Your Lordship. States.
You're making a mention on behalf of?
Mr. Paul Pasky, Your Lordship, for the private respondents
In both the matters.
in both the matters.
Yes, Mr. De.
I have no objection.
Oblige, Your Lordship.
When do you want it?
2 weeks, Your Lordship.
Yes, at the request made on behalf of so-and-so. Yes.
Oblige, Your Lordship.
Nice Lordship.
May it please your lordship, I beg to mention item number 19.
Yes.
Lordship, I am for the respondent, Lordship.
2 weeks, your lordship. 2 weeks, your lordship.
Lordship, this matter pertains to EPFO contribution, Lordship.
Sure, Mr. Subir Sen is unavailable, your lordship. Highly obliged, your lordship.
Yes, the request made on behalf. Yes.
May it please your lordship, I beg to mention item number 8. I'm praying for 2 weeks' time, your lordship.
Who is the other side in item 8? Yes. But old matter. What is
Very
it?
old matter.
Time and again, we've been seeking for adjournment.
This is what? Nokmaship.
Knockmanship.
This is with regard to boundary pillars.
What's a boundary dispute? Why you are asking for time?
Your lordship, that's my only instruction. I've been instructed
This
to.
only instruction is to ask for time. Nothing beyond that.
Your lordship,
You do not know for the reason for what.
your lordship, my senior is out of station, your lordship, because of personal work.
16 matter. What
Yes,
if you keep it pending? Also, what is it?
yes. your
9
lordship.
years already.
Nothing remains, Your Lordship, my humble submission. Because
Exactly,
with
Mr.
regard
If it
to
is-
erection of boundary pillars, now it's over 9 years.
Yes.
Everything is
Things are
settled,
settled down now. Everything.
settled down. To overturn everything, Your Lordship, at this stage,
Anyway, we'll just see. Just say it's a request made on behalf of the petitioner. Objected to by the London Council for the respondents. This is matter after 2 weeks. Yes.
Let it come after 3 weeks, my lord, because they keep on adjourning for months. Let it come after
Make
3
it
weeks.
2 weeks.
obliged.
Much obliged, your lordship.
May it please your lordship.
Yes.
Lordship, I beg to make mention of item number 16, my lord, on behalf of Mr. A.H. Karwalang.
Yes.
My lord, I see your indulgence, my lord. Can me some time, my lord, to file the affidavit, my lord.
This 20 matter, no affidavit has been filed.
No, Lordship, that's the only limited instructions, my lord, because the
It's a
conducting council,
2020 matter, isn't it? So what
Lordship.
what affidavit remains to be filed here?
because as per the last order, it states that we are yet to file some affidavit, my
There's
lord.
a very small clarifications, my lord. This pertains to the utilization of money under the SPB funds, my lord. SPB fund. It pertains to a Lafarge mining issues, my lord. Or not exactly mining issues, my lord. There was a multi-purpose vehicle where the Supreme Court says that on the basis of a polluter pays policies, Lafarge was directed to deposit certain amount as per some calculations are there formula, my lord. Now this amount was meant for development of the villages, and in the SPV manual itself it says that this money will not be diverted, and particularly when it comes to a road constructions by the PWD, my lord. Now what happened was that there was an advertisement floated by the government, and in the advertisement it says that it's a PW. The undisputed fact is that it's a PWD road, and the money was going to be used from the SPB fund. So we filed a representations. They said we objected. The village people objected to this.
Money cannot be diverted.
Yes. So the only question is now before this court, because before my lord, is whether the money, in order to develop, in order to maintain the road, whether the money has been diverted from SPV fund or from the funds of the PWD from. So only that point, my lord.
Small issue then.
Lordship will bring it by way of affidavit, my lord will reply
That
to
you
all
should
the.
do it. It's 2020 pending from 2020. Now it's 5 years. I think just on the request made on we have a Mr. H. Kharwanlam, learned edition or senior G. This is met after 2 weeks. You file the affidavit.
Lordship,
All right.
deeply obliged.
Please, Your Lordship.
Yes.
My Lord, I beg to make a mention of item number 13 of the hearing list, as the conducting counsel is out of station, my Lord.
Item 13.
Item number 13, my Lord.
You are appearing for the respondent.
Respondent, my Lord.
I'm for the petitioner.
Civil revision
Civil revision, my Lord.
pending from 2019.
Lordship.
Yes, as requested by Mr. W. G. Ray, learned counsel appearing for the respondent, and not objected to by the learned counsel appearing for the petitioner. This is met after 2 weeks.
Let it come after 2 weeks, my Lord, because after 2 weeks, matters
No
are the
objection.
3 weeks. Make it 3 weeks.
oblige, Your Lordship.
Item number 1.
May it please your lordship. Your
Yeah.
lordship, number 1 and number 2 are connected matters. On the last occasion, I was instructed by your lordship to seek instructions. So, your lordship, we've received instructions, and we are to appear for both the matters, your lordship.
So what shall we do now? It's
We-
ready for otherwise ready for hearing.
Your lordship, I'll need some time. As we've just received the instructions, so we'll need to go
That's
through
okay.
the brief.
We will not go for but then when shall we post it for hearing?
4 weeks, lordship.
Is it not too long? 4 weeks seems too long.
There'll be no other. Yes, lordship.
You just say which method you have entire appearance?
Number 34, lordship.
34. You no 34 you did not enter appearance. Now today you will.
Yes, your lordship.
Yes, Mr. JSM.
LCM, lordship.
Yes, Landed Council. On instruction submits. Landed Council submits that he has been instructed to appear for the respondent. There is only one respondent.
Yes.
Appear for the respondent. Earlier, the next matter, what order was passed on the last date? This matter to be taken up together. Just
Yes, your lordship.
connected matters.
Connected matters.
Yes, your lordship.
They appeared in item number 2 on the last date.
Okay. Just Mr. J. Learned Counsel has learned question on instruction has entered appearance on behalf of the respondent and sought for and prayed for some time to go through the matter. Clear alert. List after 3 weeks.
3 weeks, Lordship.
The second matter, just you say has pressed for Mr. JCM, Learned Counsel, appearing for the respondent, list after 3 weeks. That will mean 35. The second order will be 35. First one will be 35. Okay, entrance appearance is 34. Yes.
Highly obliged.
Item number 3.
Yes, Mr. Joshi.
May I please, Your Lordship. Lordship, the private respondent are yet to file their. Lordship,
Yeah.
I humbly pray maybe some time may be given, further time may be given to the. I'll
State
just-
also will be filing objection here.
No, Lordship.
Okay, just Mr. Petition, someone Learned Counsel appearing for the response number 3.
Lordship.
Praise for and granted. No, Mr. Praise for grant of some more time for filing objection on behalf of the said respondent.
Lordship.
Yes, appear allowed. List after 2 weeks.
Lordship, 3 weeks, Lordship.
Sorry.
No,
3
not
weeks. 3 weeks. List after 3
deeply
weeks.
obliged. Much more less, Lordship.
Item number 4.
Your Lordship, I pray for some time to file my reply. I'm paying for both the respondents, Your Lordship.
It's a revision.
Is a revision.
The what reply is needed?
Those are my limited instructions, Your Lordship.
You have to take instruction, but then revision, filing of reply is not necessary. No reply is needed. What is this matter about, Mr.
My lord, here the case was dismissed, my lord, on default. My lord, here and then we have filed a restoration petition within time, my lord.
That also was
That was also dismissed, my lord, on the ground that the counsel who has filed an application, my lord, they have stated, my lord, that she was not in a position to appear on that particular date because she was not well. On the pretext that a medical certificate was not enclosed, my lord, she was dismissed, my lord. Okay.
But then otherwise, expression application was filed within time.
Yes, yes, my lord.
It means the explanation was not accepted.
Yes, the explanation was not accepted.
What reply is needed?
I think reply is not required. Probably is not.
Anyway,
really
if
given
you
the
want, we
definition.
can post it for hearing after
Yes, Lord.
this, but then. Shall I list it for hearing?
Yes, Lordship.
Okay. You are appearing for both the respondents.
Yes, Lordship. Both the respondents.
You are Mr.
Elal Sangwaya.
On last occasion, who appeared? You were not. You did not appear.
I don't
Somebody
know,
else.
dear Lordship.
Responsible Learned Counsel appearing for the respondent. But oh, they just say the Learned Counsel for the party submit that the matter is ready for hearing. In view of the submission, this is matter for hearing after 2 weeks.
Obliged, Lordship.
Item number 5.
If it may please your lordship, as per your lordship's last order, we were required to file an affidavit, bring on record factum of service. The same has been filed, your lordship. And as per the status report from the post office at page number 6 of the affidavit, the same has been delivered to respondent number 2.
Nobody is appearing for respondent 2
Your lordship.
and 2. They're different, but 2 and 3 they are not connected.
No, your lordship. Number 2 is a Dorbar
Total is separate entity.
Your lordship. Number 2 is the Dorbar and number 3 is the Hiram CM-ship
Okay,
office.
3 is the pro forma respondent, isn't it?
Your lordship.
Here pro forma respondent. Okay. Only 2 is left.
Your lordship.
So what is to be done? We'll wait for one more. It
Another
is- have you
opportunity,
filed a
Your
service
Lordship.
affidavit? No.
Your Lordship, we've already filed. It's already filed.
And that you have already enclosed
Your Lordship.
certificate of service.
Yes, Your Lordship. If I may take a Lordship to page 6 of the affidavit.
Page 7. Village Darbar of Jangsha.
Your Lordship.
Yes. Learning Council looking for the petitioner submits then affidavit showing the factum of delivery of notice upon the respondent number 2 has been filed. Step. However, non-entered appearance on behalf of the respondent number 2 when the matter was called out. Then you say MS so and so Learned Council has entered appearance by of the respondent number 3. So what shall we do? We'll
Another
wait.
opportunity be given to them, Your Lordship.
Okay. Yes. So, leave this matter after 2 weeks to enable the appearance of the respondent number 2.
Highly obliged, Your Lordship.
Any interim order here?
Your Lordship, continuation of status quo interim order.
The interim order. This one. What was the order passed?
Lordship is status quo order passed dated 17/3/2020.
Okay, the interim order passed earlier shall continue till the return of it. Please the next date. Yes.
Highly
Item
obliged, Your
6.
Lordship.
May it please your lordship.
Yes.
The last occasion, your lordship had directed the petitioners to file an affidavit of service with regard to the respondent number 4, your lordship.
And I have just obtained the article tracking details last Saturday. The affidavit of service will be filed during the course of the day.
Just respect with the Learned Council for the petitioners. Further 1 week's time is granted for
State
filing
respondents are present.
an affidavit of service in respect of respondent number 4.
1 to 3 is present, your lordship.
Hmm?
1 to 3 is present.
This will be
your
recorded.
Your Lordship, respondent number 5 and 6.
You are today is a fast day.
No.
Okay. Just
Oblige, your lordship.
just recording.
Item number 7.
Yes.
Your Lordship, in this matter, the private respondents are to come with instructions as to whether to file an application before the district council under appropriate provision or to proceed ahead with the matter before this honorable court.
So, Your Lordship, my instruction, limited instruction was that, Your Lordship, whether fresh elections can be conducted again. Now, what happened, Your Lordship? I've been suspended again on a fresh cause of action. That is, I've challenged that before this court, and there's a status quo order being granted.
It's pending before this court, this bench.
Not this page, but this is Honorable Justice.
Okay.
Chamber.
Okay. So you have an interim order in your favor.
Your Lordship.
Order of status quo. What does it mean?
We continue. Your Lordship.
You just disputed there.
But
Then,
it's not disputed. And we're still holding, Your Lordship.
then what was the instruction you did here?
Whether to hold fresh elections or not. So my submission is that, Your Lordship, my instruction is that if the matter can be remanded back to the CM, let the matter be heard afresh again before the CM. The orders under which is under challenge before this court.
What is the order under challenge here?
Your Lordship, the order here is under Annexure 6, page 44.
This matter, my lord, I think, my lord, we have to adjourn it, my lord, because the same petitioner has filed one more writ petition, my lord.
That is what has been mixed along. We
Yes,
have
my
already
lord.
filed
On
a
that,
submission.
on that, my lord, I was directed to file an affidavit, my lord. Now, the allegation which has been brought into that matter, my lord, is this: the procedure was not followed. That was the brought, and there is a status quo, my lord. Even if, my lord, this honorable court pass an order, then, my lord, it will be very difficult for us because of the status quo to proceed with the matter, my lord. So, if the matter, both the matter can be tagged
No, no.
together.
See, what order will pass, we do not know. Let us see. We just want to know what is under challenge here.
Well, well,
The petitioner is challenging what? One of you can go one, please. This is, see the prayer, your prayer at page 11.
Your Lordship.
What do you say? The writ of mandamus to be issued directing the respondent to recall, withdraw, forbear from giving effect to the impugned judgment and order dated 14/7/2007, passed in this revision petition number 2. By which court?
Your Lordship, by the CEM of the District Council, Garo Hills. Your Lordship, what happened in this matter is that the private respondents, they have filed a revision petition, Your Lordship. Filed a revision petition before the CEM of the GHADC, whereas there's no provision for revision under the rule.
No, by that order, which way you have been aggrieved? How you became aggrieved by that order? Where is that order? Order dated 42. Which page?
Your Lordship, page 44, next just 6.
You are Manjar Ali.
I'm Manjakali, Your Lordship. Lordship, if you come to page 45,
Yes.
the 7th paragraph, Your Lordship.
It starts with?
In the instant case.
Yes.
In the instant case, the RO was directed by the AMR.
What is RO?
RO is returning officer,
Okay.
Your Lordship. Thereby directing him to inquire into the complaint filed by the opposite party.
EMR was directed by EMR. Who is EMR? Executive Member Revenue.
Executive Member Revenue, Your Lordship.
Process they were directed to. Don't know. Now, which way you are aggrieved by this order?
Your Lordship, here because there's no inquiry report, neither findings by the RO.
That is okay,
Then
but then
an order was simply passed removing me from the post of
See,
Gaubura, Your Lordship.
remember the post of
Gaubura.
you are Gaubura of how Gaubura is elected?
Lordship, by election.
So you want to say that revision was not maintainable.
Revision is not, Your
So he
Lordship.
could not have exercised any
Your
jurisdiction.
Lordship.
Yes, where is the power of revision then?
To that extent, I agree, Your Lordship.
That is enough. That is
But
good
there was
enough.
only a mistake in the nomenclature, Your Lordship. In fact, it should be an appeal.
See, it should have been what? Mistake in the nomenclature, the appeal and revision.
Well, kindly
The
see,
nomenclature is
Your
everything
Lordship,
here.
Page 44. Page 44, Your Lordship, second paragraph.
But then it is not a revision by the same authority, isn't it?
No,
No, Lordship.
Page 47.
44, Your Lordship.
Same order, Your Lordship.
Yes.
So that's why my submission is that, Your Lordship, let the matter go back and only allow me to convert this particular revision into an appeal.
Your
And
Lordship.
the matter be heard again.
Your Lordship.
That means the
as it
court
is-
will help you to this thing, rectify
Your
the
Lordship,
mistake.
also, well, when a mistake committed on the nomenclature, Your Lordship can always have some decision on that point, Your Lordship.
Yes,
Because
sure.
here, at the time of hearing also, Your Lordship, can we see page 44? The opposite party also has no objection in hearing the revision as a review petition.
Revision as a review petition.
Your Lordship.
The review by higher authority.
Review by
Review-
CEM.
Your Lordship,
In
as
fact,
it is.
even
CEM
review
order
also is
can
not
be-
maintainable. It should be by way of an appeal.
Again, can there be inherent power of review? Review has to be specifically conferred by the statute.
Your Lordship.
Then
Your Lordship, as it is the appeal, they have exhausted that remedy, Your Lordship. If you come to page 4, they have filed before the EM as an appeal. Page 27, Your Lordship.
EM
in
has
ex-
appellate jurisdiction.
Your Lordship.
Your Lordship,
just
they
praise
went as
this
an
piece
appeal.
of, which I
They
have
went
submitted
and filed
earlier.
as an
Page-
appeal. Page 27 in Extra 4. Your Lordship, the appeal was filed by the private respondent before the EM itself.
They filed the appeal. And then you filed the revision.
No, Your Lordship.
Counter on illegality by another illegality. Of what?
Your
Oh, no,
Lordship,
they
even
filed
the
revision.
revision was filed by
Appeal
the
also filed
private.
by them, revision filed by
Your
them.
Lordship.
Page, what did you say?
Page 27 in Extra 4.
Yes. This is a revenue appeal.
Revenue appeal. Your
Then,
Lordship.
as per the law, the revenue appeal goes to whom? Should go to whom?
Your Lordship, I'll just place this. It will be clear, Your Lordship. I've already placed earlier.
Everything will be clarified.
Your Lordship.
Please.
Can you see, Your Lordship, the 3 columns that are prepared? The 3 columns.
Yes.
The order is 18/5/2015. I was removed as Gobora by the revenue officer, that is the SDO.
See, the London revenue location applies to your thing. That's been adopted.
Your Lordship.
There is amendment. With certain amendment.
Amendment, no, Your Lordship.
This was the London revenue regulation. If it is adopted by the Garo Hills District Council, then who will discharge the role of a commissioner and all those things?
That I've stated, can you see, I'll just bring to that column first, Your Lordship, what has
Yes.
happened.
Okay, okay, yes, okay.
Column number 1, Your Lordship.
Yes.
18/5/2015 is the order which I have been removed
Yes.
by the revenue officer. Okay. Now, Your Lordship, the correct provision is under law. We should file a first appeal under section 162B, an appeal to the Deputy Commissioner, which has the same power as the EM, filed before
So-
the EM. But what we have done, Your Lordship, what the private respondent has filed,
In
he has filed an
see,
appeal.
in the context of district council, who will discharge the role of a deputy commissioner?
Executive members. Yeah.
Where is that?
As stated below, Your Lordship, there's another table.
Okay.
The state government will be the district council, commissioner, division,
Okay,
and
okay, it's
director
all
of
right,
land
it's okay,
records will
okay,
be the
yes.
CM. Deputy commissioner will be the executive member.
Okay, so your appeal was filed before?
My appeal was filed before the EM. But it should be a first appeal, but I have filed an
So
appeal.
your appeal was incompetent. It was not only the 147 appeal under 147.
Your Lordship. Yes, it was wrong. It was filed under a wrong provision.
And it was before wrong authority also.
No,
No,
the same
it was
authority,
before same
before
authority.
EM.
Okay. And then
The correct provision should be first appeal under section 162B. Now, Your Lordship, what has happened is that instead of filing a second appeal under 162C, I filed a revision, Your Lordship, under 170 of the regulation. The next page, Your Lordship.
yes. Yes.
Your Lordship, I have quoted the relevant provisions. What is 162A, 162B, 162C, and 162D? Now, Hymal's submission is that only that a wrong provision has been quoted before the
Your Lordship,
competent
I
authorities.
I have an objection to that. Even if they were to go as a second appeal before the CEM, Your Lordship, the time period here is only 60 days.
So it was time barred.
Time barred, Your Lordship.
But before that particular
Where is anyway? Let her place her case then. We'll just see. If it is, see, we do not know what it is to do with your present suspension here. If we are dealing with certain order, any relevancy?
Your Lordship?
Your present suspension,
Yes,
which is under challenge before other bench,
Your Lordship.
what relevancy it has with this case now?
The suspension, because I'm still continuing as a Gobara. There's some
So that
fresh
is okay. So
complaints
what is
against me.
we are concerned here with the legality and correctness of certain orders,
Your Lordship?
isn't it?
Your Lordship.
So whether you see these are held correct or not correct, what bearing it will have here? Say supposing if this matter is decided in favor of the petitioner, then what happens to you? What is the consequence for you?
I will
You will
still
be removed.
continue. I will still if they succeed, Your Lordship, then the matter has to go back again for fresh decision.
Why? If it is not remanded and if they are successful, then what happens?
No, because their submission was that the matter was not heard based on.
No, that is okay. Do not say what order. See, do not. I'm just asking. Court is asking you. Just assume that writ petition is allowed
Your Lordship.
without remanding it back. Then what consequence it will bring to you?
My humble submission, Your Lordship, there's no consequence. Why? There's another fresh complaint. There's a fresh writ petition also.
So this matter has become
I will
infructuous.
continue as a headman.
So this
Then
matter
I
has
have to-
become infructuous.
It
Say if you say that
then
this,
becomes fractures also, Your Lordship.
if you say that the decision, irrespective of the way which it goes, would not have any bearing with you, then why should you keep it pending because the
Absolutely,
pendency of the other matter?
Because it's a fresh.
So that is
allegations
inconsequential.
against me,
Is inconsequential.
Your Lordship.
So matter has become infructuous. Is it that what you want to say?
Your Lordship. So because the
And who is the
complainant,
petitioner here?
petitioner here is Mr. Who is
Manjak.
he was the Gowda
Your Lordship.
and he was removed and
Yes.
you were appointed.
Yes, Your Lordship.
That is why this is it correct? Lordship, what has happened here is that I was removed. Then I filed a complaint. I was removed, then I challenged. Thereafter there was a writ petition before this court, and this court has filed certain orders. On the basis of that, they were reinstated. Now what happened, Your Lordship? Then it came to light that
Just a minute. You were holding it before them, isn't it? Now, once you were removed, the petitioner was appointed in your place as acting Gaubuda or as a regular Gaubuda?
that point of time, Your Lordship, because, Your Lordship, there was a writ petition disposed of by this court, a review, Your Lordship. I'll just come to that, Your Lordship. After the review was disposed of, I was reinstated in 2021.
As a regular or acting?
Regular, Your Lordship.
We have problem. Yes.
The fact is this, my lord, about the filing and the counter file, my lord.
This court is yet to get the facts. Mr.
My lord, the case is this, my lord. Petitioner was before this honorable court. They have obtained an order, my lord. They got an order in their favor, my lord. Against that order, a review was filed, my lord.
Order in respect
Review
of
was
what?
filed on the ground, my
Just a
lord.
minute. Order in respect of what? Just tell us.
Of the removal of the Gaubuda, my lord. He was
Gaubuda
removed.
of a regular Gaubuda.
Yes, regular Gaubuda. There is no acting Gaubuda.
No.
There is
So
no
there is
acting
nothing called acting.
No, my lord. So, district council appointed them on the basis of an High Court's order, my lord. Then that order was reviewed by this honorable court, and the matter is still pending. What is before my lord now? The writ petition revived, my lord, because the review was allowed. Review was allowed on the ground, my lord, because there was an ex-party order against of them.
Who filed the review petition? Writ
They
petition
have
was.
filed. Writ petition was filed by them, my lord, Manzak Ali,
They were.
and Zoharul Islam has filed the review petition, my lord.
So by virtue of the order passed, the writ petition,
Yes.
the petitioner is stated.
Yes, my
He
lord.
files a review.
Yes, my lord.
The High Court allows that review.
Yes, my lord.
Then
And the
situation
order
takes-
was
take a reverse. The
Yes.
petitioner is removed.
removed.
He comes back.
He comes back.
This is the position.
This is the position. Subsequently, what happened, my lord? There was a complaint. There was a complaint by another individual where they are alleging, my lord, that individual is the brother of Manzak Ali.
Whatever it is.
Yes, my lord. On that, my lord, there is a status quo. We say that, my lord, he doesn't exist now because there is already a termination order. But court has passed an order of status quo, my lord. Status quo, my lord, it is not clear which way, my lord. The status quo again, my lord, there is a grey area, my
So
lord.
he,
There is a claim
now,
and counter claim.
on the basis of the new complaint, when was he removed or suspended?
He was removed in 2025 only, my lord. This year only he was removed, and this
And
matter
he says that he is holding the office.
he is claiming that he is holding, my lord, but we have terminated him.
It's okay.
We have suspended him. Once he is suspended, my lord, he cannot act, my lord. If he is acting, then it is beyond the law.
Termination is not state, but then status quo is.
Yes,
passed.
yes, status quo.
That means
because the
that
claim.
means that will basically make this termination more stronger, isn't it?
Technically, yes, my lord. Whichever way, my lord,
No,
my lord,
if you say the status quo order was passed
My
after
lord.
termination order,
my lord.
that means that termination remains, isn't it?
No, not
It's a
termination. It's suspension, my lord. Not termination. It is suspension. So
that
now,
means the suspension remains.
yes, suspension.
So he is suspended person,
Yes, my lord.
but then he has not lost his right. So
He has not lost his right, my lord. There is no doubt about it, my lord.
That is under adjudication.
Yes. Now, if my lord pass an
Now-
order in this
Now
matter,
tell us if this petition is heard at this stage now,
my lord,
and if this writ petition is allowed,
my lord.
then what bearing it would have on him
Now, if this writ petition is allowed, my lord,
without remanding back, just allowed.
my lord, then he will be removed, my lord, because that appeal which they have filed, my lord, he has filed before the CEM, it was in his favor. That order has to be set aside. Once that order is set aside, my lord, then
So
automatically
it
the petition,
means, it means if this writ petition is allowed,
my lord.
and if he loses his office now,
Yes.
then the case which is pending before the other court also, that also will become.
It goes, my lord. It become infatuous, my lord. There will be no cause of action then.
But then, would it mean that the petitioner comes back to office?
If my lord pass an order, it depends on my lord's order.
There is no question. If it is a post to be filled up by election, why should court appoint somebody? Court can appoint somebody
That-
for the time being.
Yes, my lord.
But then otherwise, it is to be by democratic
If
exercise.
my lord recollect, I have given a proposition on the instruction, my lord, that both the party goes for election, my lord. And if there is a third party also, they can also participate. Whoever has the majority, my lord, support, they will become the headman. Because now it is a long time, my lord. This order, which was passed in favor of the petitioner, was in 2017. Now, whether he still enjoy the majority support of the village or not, or whether the petitioner still get the support or not. So, if there is an order of fresh election, my lord, that will be a much more appropriate thing, my lord. Then the person who will be elected, my lord, he will have the majority support of the village.
Yes.
Lordship, in that regard, I will have to take instructions whether the petitioner will.
Are you ready for that?
I have the instructions on that.
No, if you're ready for then you'll be saved from that other matter also. That will be the double thing.
No, the manner
It's
in
like
which-
something would come
which
from.
is pending in the other court, manner in which has been suspended. It's a total violation of.
So, first you get clear of this, then we'll see, my lord.
But your lordship, since the private respondent is under suspension, will he be allowed to contest the elections?
That is where you see. That is why.
No,
instruction
that my
is
lord,
needed.
that my lord, I will
That
take
is where,
instruction.
you see, the court is asking you. Okay. Now, if you are ready for election, then we will close all those chapters. And we will make an order saying that he will also be able to take part in the. Of course, on the condition that all those proceedings
Be
which are
withdrawn.
pending till date will be closed.
Your lordship.
Will be closed without, you say, like any benefit to any of them.
That proposition will be the much more benefit for both the parties, my lord. Now they are staying there, my lord, on the strength.
Provided they are agreeable to you.
Probably they will not
That
agree.
can be-
Probably I'm 100% sure they will not agree, my lord. I don't know about the petitioner, but the private respondent, because here, my lord, he is enjoying the office, my lord, on the strength of the order of the High Court. Whether he has the support of the majority of the villagers or
You
not.
say he is suspended.
At present, he is suspended, my lord, but he was enjoying.
So it means right now, say supposing, if you say that his suspension has taken place, it has been made effective, and the status quo basically is nothing. It will confirm suspension at this stage.
My lord.
That means no one is holding the post of Gowda at this stage.
No, my lord. There was a
present,
third
we are still
party.
running, Your Lordship.
Third party, my lord, there is a temporary appointment for the third party, my lord.
My instruction is that after the status quo, because we came here, Lordship, before this court on time.
Was whether somebody was appointed after he was suspended?
Yes, my lord.
So he is appointed as what? Regular?
No, temporary, my lord.
So
temporary.
there is a provision of temporary appointment.
There is no such provision, my lord, but we only just for that gap, my lord.
But then you said that acting is not
Acting
there.
is not there, my lord.
So temporary is something like acting only.
Is acting only, my lord, but the terminology which is used is a temporary, my lord, and it's for 6 months. It is only, my lord, for the welfare of the village, that there should not be a vacuum in the office of the Gowda, for that purpose.
Already you have appointed somebody temporary.
Yes.
They have appointed the younger brother of the petitioner, Lordship.
What is the problem? He's a separate.
He's separate. You can make him. But my lord,
My submission is that we're still continuing, we're still holding the case after the orders passed by this court.
interestingly, my lord, the irony of the matter is this: they have not made him as a party, my lord, in the second proceeding,
Lordship.
and he is making an allegation, but in the petition that he's the brother. If he's the brother, then
But
he
then
should.
he has not made. He has not been made a party.
He has not been made a party.
Anyway, that is for that court to.
So let them
consider.
take instruction, my lord, both the parties, my lord. We are ready to conduct election.
Then finish it. What purpose will this thing it will be served? We do not know. Say supposing if this matter is decided at this stage, then what happened? Do you come back to the office automatically?
Your lordship. If this order is set
It
aside,
seems you are not very sure. You are
lordship,
looking
if-
at him for
your lordship,
confirmation.
Now,
if
my
the
lord,
order impugn is
for
set
him-
aside, we will.
For him to come back, my lord, it is only on the strength of this order of the High Court only he can come back, my lord.
It is
Otherwise, my lord, otherwise a third party has been appointed. Maybe his brother or his sister, I don't know, my lord, as per their allegation. But someone else has been appointed, my lord. That is why, my lord, what I am suggesting, my lord, before this honorable court, my lord, that there should be a fresh election. And whoever enjoy the majority of the support of the villages, my lord, let him be the headman. Now, from 2017, my lord, they are dragging this.
This was reviewed in 2022. The order was, earlier order passed this court was reviewed on 22/7/2022.
Yes, my lord.
Yes, what is to be done then?
You are not ready to face election.
I have to take instructions.
Let both the party take instruction, my lord, whether they are ready to face election. We cannot face election. But no, sir, I want to get rid of this. Take instruction.
Your Lordship will take instructions whether to proceed ahead with fresh elections or not.
No, man, it's just-
Yes, Mr. There, shall we record it?
My lord, that
Your
will be better, my
proposal?
lord. Yes.
Shall we record your proposal?
Yes, my lord. That since there is a all this hodgepodge, my lord, we are ready to conduct election, my lord. Let both the parties take instruction, my lord, whether they are ready or not, my lord. But we are ready to conduct election.
There is no other stakeholder apart from.
No,
This
as per the claim of the.
So far as this case is concerned, it
There's
should
no
not be
other.
something like that. Somebody third party comes and files a review application later.
I don't think so, my lord. In this matter, they can intervene.
But then, whether that will serve any purpose, whether councils are ready for that. If the landed councils are not ready, then parties will never be ready. Now that is the main thing, isn't it?
Then this matter has to be decided, my lord.
Well, I'll take instructions on that.
1 week, my
You are ready with that?
Your Lordship will also take instructions.
Okay. Right, Learned Counsel for the parties. Just say Mr. Dale, Learned Counsel appearing for the respondent number, appearing for the GHDC. Submits that this matter is pending for long time without any meaningful purpose. He submits that if the parties herein is if not if the parties if the petitioner, and how many respondents are there? Private respondents, how many are there? Only one.
Only one in this matter.
Okay. If the petitioner and the private respondent is ready to face election for the post of Gaubuda of which area?
Which area?
Comma, the GHDC is ready.
Patrokata. Patrokata.
Gaubuda of how do you spell it?
PATHORKATTA village.
What is the last line you said? Comma, the district council is ready. District council will conduct the election, isn't it?
Yes, my lord. District council.
Just wait for a moment. After we finish, then you consult with you.
No, we are not consulting, my lord.
Who got distracted?
We are arguing.
Sorry, my lord.
And the district council is ready to conduct the election. Stop. He submits that once. He submits that considering the long pendency of this matter, the holding of election would settle the matter permanently. Stop. The Learned Counsel for the petitioner and the respondent number 6. Grant us some time for taking this instruction. How long will it take?
2 weeks. Your Lordship.
How long will it take to?
2 to 3 weeks.
Why this is 2 to 3 weeks? You just say something. Why it is not shorter time then? Make it 1 week.
2 weeks, Lordship.
Your Lordship, 2 weeks. The
Or you do not want to. Anyway, this is a problem. Yes, just time. Prior allowed. List after 2 weeks. Please see, it is useless by keeping this matter pending like this.
Item number
Yes.
10.
Yes, another district council matter.
Lordship.
They are also same parties.
No, my lord. It's a different subject matter.
Yes.
Your Lordship, this is with regard to cancellation of Pata, Your Lordship.
Yes.
Lordship, what happened in this matter is that in the village, Your Lordship, there's a general meeting which was held in the year 2003, where in this general meeting, Your Lordship, they have decided that the property of the village shall not be transferred, neither gifted to anyone who is outside the village.
Who have decided?
Your Lordship, the Maharis, Your Lordship, the Maharis and the Chras. Your Lordship, if you come to page 12, annexure 1, it's the general meeting.
Yes.
Your Lordship, translated copy is at page 19.
Yes.
Your Lordship, if we come to point number 3, there has been a discussion about Sri Pojendro Marak, one who seek permission for the measurement and occupation of the land, but since he married a non-tribal, he was not allowed to measure or occupy the land, and all the villagers were also informed that they will not be allowed to measure, gift or sell the land to others, bracketed non-tribals. Lordship.
That's
What
okay. I think there is a law also, isn't it? You cannot transfer the land.
Your
Land
Lordship.
Transfer Act is there.
Your Lordship.
Yes.
Your Lordship, then after that, Your Lordship, the respondent 4 was given a portion of the property, five bhighas, Your Lordship, in the village, only for cultivation. Thereafter, Your Lordship, a part of this property was transferred to respondent number 5, who is not a villager of the said village, Your Lordship. He's an outsider. Then, Your Lordship, here what happened is that the respondent number 4 claimed that this property was transferred during the previous Nokma, Your Lordship, through by an agreement with the previous Nokma.
What is the order passed by the District Council?
Order is at page 58, Your Lordship.
Who are you and which way?
Your Lordship, we are the petitioner. Here is the Mahari, Your Lordship, of the village. Your Lordship, in this order, Your Lordship, there's no provision under the land revenue regulation to cancel pata, Your Lordship.
There is no provision to cancel.
For cancellation of pata.
Yes. Is it correct?
No, my lord, there is provision which can also cancel the patta. There are terms and condition which, if it is not followed, my lord, then only patta can be cancelled. And if they don't pay the revenue fees, my lord, those are the two grounds, my lord, on which a patta can be cancelled.
So that is not correct to say that there is no provision to cancel.
It is not that in a wider sense we can say that there is no such provision. There was an order of this honorable court, my lord, Shillong bench, my lord, where they have said that there is no such provision, my lord. But the law is there, my lord, where patta can be cancelled. But this matter, my lord, is not under that provision of law, my lord, which they have not cancelled the patta, my lord.
Your Lordship, under that law, the cancellation of
Now,
pata.
what is the position of law then instead? Whether the authority has the power to cancel it or they don't have the power to cancel it?
In this subject, my lord, they doesn't have the power to cancel.
power, Lord.
In this subject, my lord.
Except civil court.
Not only civil court, but lord, if they become a defaulter, my lord, they don't pay the revenue of the land, my lord. Then
Here,
only patta
you
can
see,
be
the order passed by the District Council authority is under challenge.
my lord.
We'll just be confining ourselves to the legality and correctness of those orders.
Yes,
Nothing else.
Yes, my lord.
Nothing more than that.
Yes. Now the petitioner has to show, my lord, this order was passed beyond the law.
Okay, who approached first the District Council?
Your Lordship, the Maharis itself. the
Maharis
petitioner.
means you, the petitioners.
Your Lordship.
So you approached the District Council.
We
Give-
approached the District Council, Your Lordship.
Yes. And
That is at page 39. Annexure 5.
Yes.
After this, Your Lordship, after we made this complaint,
Now
there
you
was
have made
no
a complaint for cancellation of the land patta.
cancellation of the
And now
patta.
you yourself say that there is no power of cancellation.
Your
of patta.
Lordship, as per the order, as per the judgment passed by this honorable court, there is a provision which says that patta cannot be cancelled except when the person holding the patta does not pay the land revenue.
So there is no
tax.
absolute bar,
There's no absolute bar.
isn't it?
However,
That-
Your Lordship, that can only be made if it is mentioned in the said order that whether the revenue is being paid by the person holding the property or not. However, Your Lordship, in this appeal, there's no mentioning as
Anyway,
to
let us see what is your complaint first.
page 39, Your Lordship.
Yes.
To the Secretary Executive Committee, dated so and so, subject request for cancellation of land patta applied by Sri Sangma. Sir, with due respect, we the close relatives of Sri Stalin Sangma has an objection towards the land patta applied by him because we don't know anything about the said land patta, and without our consent and witness, Nokma alone does not have the power to measure the land, and along with that, on the village meeting dated 23/11/2003, we have decided that we won't let anyone to make land patta even though he is a resident of a village. As per our inquiry, there is no record on the issuance of land patta or direction, and most importantly, the record of close relatives as witnessed in the document provided by the Nokma to Sri Stalin Sangma. Thus, he does not have the authority to pursue patta with this kind of land document. No one can make a patta without our consent, that is the trust. On 3/5/2009, the meeting took place among the Nokma Trust and the residents of the village, and we have passed the resolution that we will not give away the land.
Sir, what is the blank part? Dot part is what? What?
Your Lordship, it's eligible, Your Lordship.
No, this is a translated version of this.
Translated, Your Lordship.
Yes. So why then why it is gap then? Your vernacular one is totally legible.
Your Lordship.
Then no, this is the last. This is the thing. This is the last part. Thus we request to cancel the application of so and so. Yes.
Thereafter, Your Lordship, there was no action forthcoming from the district council. Thereafter, another.
To what extent you can exercise your authority in the settlement of land?
Your Lordship, the Maharis and the Chras in Garo community, Your Lordship, especially the Nokma, he cannot take a decision by himself, Your Lordship.
No, what
It has
what
to
authority Nokma also has for settlement of land? If it is settlement is to be done by the district council, the authorities of district council, is it that the addition of the Assam Land and Revenue Regulation? Is it? Which way, what law guides the settlement?
Your Lordship, with regard to the settlement of land and all, it has to be decided by the Nokma along
On
with the
what basis you are
Maharis and
saying?
Chras.
On
It's a customary practice, Your
where
Lordship.
is that? Show us. You are making, you are just saying something.
There's
See,
one.
until unless there is legal recognition too. So that if you say that is a customer practice, why settlement is not done by Nokma? Why by the district council?
Your Lordship, here because the patta was already issued by the district council, Your Lordship.
So
The
then,
property
if,
was already registered.
if in a matter where patta is issued by the district council, what right you have to interfere?
Your Lordship, the Maharis and the Chras, along with the Nokmas, they take decision with regard to the Aking land, Your Lordship.
Then do you want to say that district council action is guided by your decision?
Your Lordship, here in this matter, the Pata was registered without our knowledge, Your Lordship.
That is why your knowledge is required. That is why the court is asking. Just show us why. Where is that requirement? Either by virtue of custom or by virtue of any
By
other
virtue
law.
of custom, Your Lordship, there's one book which is
That show us.
Garo customary law, Your Lordship.
Then show us that at least there. See whether district council has adopted the Assam Land and Revenue Regulation Act.
Yes, Your Lordship.
In such a case, there must be something to show that district council, while issuing patta, must take consent of the concerned of one.
Your Lordship, here.
Let us show us there.
Your Lordship, here what happened is that the private respondent, they have showed some letter, Your Lordship, no objection to the district council given by the previous Nokma, Your Lordship.
Okay, but then first you show that you have a locus. What is your locus?
Your Lordship, here we are
Is it something like that when this Aking land is settled?
Your Lordship, here we are
Who makes settlement of Aking land?
Your Lordship, the Nokma along with the Maharis and the
Then
Chras.
the district council has no role in land matter.
Your Lordship, when the property is to be registered, that time the power of the district council comes into play. Your Lordship.
Registration under what provision of law?
Under the Assam Land Revenue Regulation.
Where is that provision? Show us.
Your Lordship, with regard to the customary law, there's one book, Your Lordship, Garo Customary Practice by Jenseng Sangma, Your Lordship. As today, it's not.
No, whether that book, how much it will be, how much this court will be bound by whatever is written in that book.
Lordship, because that book, it's mainly referred in most of the Nokma cases, Your Lordship, as per the Garo customary law.
So that has been accepted as an authority by the courts. Do you want to say that? But this court would be interested to know that if you say that district council has adopted the Assam Land and Revenue Regulation, then it is assumed that the regulation contains some provisions for settlement of land. Now, in that settlement process, how much district council will be bound by the decision of the Nokmas?
Your Lordship, here
that you have to show us, that you have to show places.
Your Lordship, here what happened is that because the property is registered before the district council,
See,
and now
the application was with regard to what? This private respondent's application was for what? He did not say mere registration. He wanted the patta should be issued to him, isn't it? So it's a settlement. There is a difference between registration and settlement. So you can settle a land which you hold.
But Your Lordship, here because the patta was already issued under the name of the private respondent, and the district council does not have the authority to cancel such patta.
Just a minute. You are seeking cancellation of the patta, isn't it?
Which was obtained
Now,
illegally.
cancellation of patta issued by the district council, isn't it? So issuance of patta, that means the settlement of land, isn't it? By issuing the patta, a certain part of land has been settled with him, isn't it? Now for that settlement, there's provision in Assam and Railway Regulation. What are those provisions? Show us. And what is the requirement under that provision? That is what you show. You can show that some certain portion has been violated, then we'll take note of that, and then we'll subsequently come to the order passed by the EM and CEM.
Your Lordship, in that regard, I'll take some time, Your Lordship, to do research on that.
What is the order passed by the district council? The first order and the second order.
Page 58 is the final order, my lord.
And what is the first order?
First order is in page 50, Your Lordship.
Page 50.
Annexure 7.
Yes. Why there are many blank areas? There is a problem.
Your Lordship, we'll get a proper translation also, Your Lordship.
Madam, see the matter is pending from 2018. What is the ground you have taken in the writ petition?
Your Lordship, here a ground that we've taken here, Your Lordship, is that since the district council has the authority to issue pata, Your Lordship, they should also have that authority to cancel such pata obtained illegally.
Now, your both the orders are against you, isn't it? You are challenging the concurrent decision. Now, what has been held in the first order?
Page 50.
Your Lordship, they have, in this order also, Your Lordship, they have relied to this judgment passed by this honorable court, Your Lordship.
Yes. So they have not gone to the merits of the claim. Instead, said that there is no provision of cancellation, and they, on that basis they have rejected. Now, what is the order of the CM?
Your Lordship, CM also he passed the same order, Your Lordship, we have heard that one.
Yes, page 58. What is this order? What does it mean?
My lord, if I can just apprise this honorable court, my lord, the order of the CEM.
Yeah, it seems very...
No, my lord, according to my understanding, my lord, what he meant to say, my lord, that the case which has been filed in which court, my lord, I have no authority. He meant to say, my lord, because the case was supposed, the appeal was supposed to be filed before the revenue board, my lord. However, the appeal was filed before the CEM, my lord.
No, but then there is no revenue board for district council matter. How revenue board will come?
Revenue board is there, my lord. If my lord may kindly see the green book, my lord.
Mr. Nangri,
There's an amendment, Your Lordship.
There is an amendment, my lord. Which
that
says,
is
my
what,
lord,
that is how the district council,
yeah,
revenue board is the district council, isn't it?
it will be set up by the district council, my lord, revenue board, and it is the CEM itself. But they have filed in a wrong forum, my lord. That's why he has not entertained the appeal, my lord.
Sir, he has already indicated you come by a proper application, a proper appeal before the Meghalaya Board of Revenue.
If my lord may kindly see the green book, my lord.
Just a second. Just let us try to understand the order first. My court is not my, it is not the appellate court, isn't it?
Yes, my lord.
So then they could have preferred an appeal then.
Yes. They have preferred the appeal before the CEM, my lord. If
No,
it is
but then
CEM,
by this order, after this order, they could have approved.
they could have gone to the forum.
Then, yes, madam, what is the problem then? Why you have filed this writ petition and you kept it pending for so many years? This order only says that he had no authority
Your Lordship,
as chief executive member.
Yes.
According to him, you should have approached the Board of Revenue. At Board of Revenue, so far as the district council is concerned,
We have our own board of revenue.
that is why in the previous case you have placed it, isn't it?
If my lord may kindly produce page 299 of the Green Book, my lord. It is very clearly mentioned, my lord. 299.
Then what do you do? Shall we allow them to file an appeal before saying at this stage?
It's too late in the day. Your Lordship.
We know that he'll be saying.
2018.
Then they will be formless, my lord.
Definitely, there must be challenge something, at least something.
My lord may kindly see.
Is there time limit for that?
There is no such time limit, my lord.
Yes.
Any reference to the Board of
299.
Revenue, 299, my lord, the
Yes.
last section,
Any reference to the Board of Revenue shall we consider?
as the Chief Executive Member.
Yes.
So it is the Board of Revenue of the District Council.
No, then chief executive member, then it's okay.
He will be the Board of Revenue, my lord. He will decide the matter as a Board of Revenue, not as the Chief Executive Member.
It's okay, but the same thing, it's only mere thing, clerical error. So this order is otherwise than erroneous then. This will set aside, will set it back to this thing, appellate authority. He should have entertained this.
Lord, only because of this tactical.
Only because on the heading it has been said in the court of the chief
Chief
executive
Executive
member.
instead of the Board of Revenue.
Then see, if you go by the meaning of these things, any reference to the Board of Revenue in Assam London Revolution as amended shall be construed as a reference to the chief executive member. So that is enough, good enough. It takes care of that. So let the matter go back.
And let the matter go back, if my lord friends.
So there is what you will say. Yes, which way you resist that?
Because the Lordship, the order was passed way back 2017.
That is okay, but then this is the wrong thing.
For almost 10 years.
It's the wrong thing. Just because he found that it is written in the court of the chief executive member, he has rejected it. And there is also nothing wrong in it. Why? What is the wrong if you go by this amendment?
It's just that they have addressed it before the wrong court. That's
Wrong
all.
forum, man.
Wrong
No, but then basically, in actual sense, it is not. Why it is addressed before wrong court? What is that petition? Let us see.
It should be before the Meghalaya Board of Revenue, not in the court.
No,
the
Board of
chief
Revenue.
No.
It has to be before the Board of Revenue, my lord.
Board of Revenue.
District Council.
No. It is before the chief executive member. Why not? Where it is the availability of that nomenclature Board of Revenue is not there for district council. Where is your petition? This thing memo of appeal? Yes, in the court of the chief executive member at Garo Hills. So what is wrong in it?
If my lord may kindly come to page 103, my lord. 103
Of the
Green Book, my lord. The original.
yes.
My lord may kindly see section 3, clause 3, my lord. Reference to a tribunal in the said chapter or section or in the said rules shall be constituted as reference to the district revenue tribunal to be constituted by or under the order of the executive committee for disposal of all appeal case pertaining to land revenue matter, my lord.
This is a tribunal.
Yes, it is the tribunal only, my lord.
No.
Yes, my lord. Because this section has been
Now
amended.
you are
Now my lord may kindly,
making more confusion. It's not fair.
now my lord may kindly see.
No. It speaks about the reference. Where is the question of reference here? Where is
Well,
the?
we have to go with the amendment only, my lord.
No, that is what.
And
So
it
that
refers
is,
to the Board of Revenue, my lord.
that is 299.
Yes, my lord.
That is what. Where is that London Revenue Regulation? At which page it will be? London Revenue Regulation. Which page of this compilation?
It is on page 103, my lord.
No, 103 is the. Is it one? What is section 147?
That is from the main act, my lord.
Yes, that is what. That is what we need.
Yeah. One 47 says, my lord, authority to whom appeal lies.
This is a publication of which year? There is. We do not have that thing. The other book.
This
That Jain Chaudhury's book and or something. What is that? Yes, that is all right. The appeal right lies to the same board against this under 147.
Your Lordship, I'll do some proper research, Your Lordship, in this
That's
matter.
okay. You do not have to solve it, I think. Why not? There is nothing wrong. What is right now with you? What research you need?
Lordship, I'll need some time, Your Lordship, 2 days time.
What is in your favor?
Hmm? We'll set aside the order of the appellate body and then send it for reconsideration. That is what. What research you want?
For time for the private response number 5.
Yes.
So Lord, in that regard, I will may allow some time to take instructions.
What instruction? No instruction is needed. Court is passing an order on consideration of merits. It's not dependent on your instruction.
Because what limited understanding that I have is that the application ought to be addressed in the name of the Board of Revenue. Ultimately,
That is what your argument is. We can note it if you say.
Go before the CM.
Okay, if you say that, we take note of that and we'll decide the matter then. What more instruction you need?
But with regard to
But according to what, it should be addressed to who? As what?
my limited understanding, it should be addressed to the Board of Revenue. But ultimately,
Where is the Board of Revenue in the District Council?
go to the CM.
Where is the Board of Revenue of District Council then? See that part which Mr. Day has pointed out, that page 299 of that green book. That clarifies the entire issue. Nothing remains.
299 page number. Yes, that's right.
Yes, what further instruction you need?
Lordship.
Here it says.
No, she is also willing to take it. You also take it. She also wants to take it at wants time for instruction. Just sit. How long will it take?
Your Lordship, order may be passed, Your Lordship.
Just now you said you want to take instruction and then
Wait a minute. Let it go back.
it was settled in favor of 2 persons. In favor of how many respondents?
Respondent number 5, Your Lordship. 5.
Mr. Nangri is appearing for whom?
Number 4.
Who is 4?
4 is.
Okay, 4 is also a private person.
Your
So this land was settled in favor of both of you.
Lordship, firstly, the land was settled upon respondent number 4. Then a part of that land, Your Lordship, was settled by respondent number 4 to respondent.
There was a further transfer. So basically, your challenge is to the settlement made in favor of the respondent number 4. So if that goes, the respondent 5 will automatically. Okay, hard.
But only one small favor. Not if this honorable court passes the order, my lord, I have no objection. Only that, my lord, only my lord, it may be recorded that the status quo be maintained as on date, my lord. Number 1, number 2, my lord, if there is any question or limitation, my lord, then that be kept open also.
Yes, hard. Just write down the names, Ranika. I think was so and so, so and so, so and so. Okay. Then you say by this, by give a paragraph. No problem. You know, na? Everybody. You can take the thing. Just see, give it a try. If there is any mistake, we'll correct it later there. Yes. Sit down, you can sit. This repetition has been filed, paragraph, huh? This repetition has filed with the petitioner. Assailing the order dated, assailing the impugned order dated 15/6/2016. First you say assailing the order dated 14/3/2017. Passed by the vessel number 3, comma, the executive member in charge, Land and Revenue, GHDC, and order dated 15/6/2016, passed in GDC stroke revenue appeal number 7 stroke SC. You will get it at para 2 of the writ petition. Okay. By the respondent number 2, that is the chief executive member, Garo Hills Autonomous District Council, by which the prayer of the petitioner for cancellation of patta issued in favor of so number 4 and 5 was rejected. Give it back. Stop. The fact of the case is that an area of fact of the case is that an area of land measuring about 5 acres located at NH 51 in West Garo Hills just a minute. This land was now this settlement was made by the NOCMA.
NOCMA, Your Lordship.
Then
it was given to respondent number.
Acha, that is not by the district council.
No, Your Lordship.
And you challenge it before the revenue office.
Your Lordship.
That settlement by NOCMA, that was challenged. Not by the settlement of the district council.
By the settlement of district council, Your Lordship.
I have not understood.
Because this.
Here, paragraph number 3, you say the petitioner says there is one of four who, under the pretext of juming, was given a land measuring 5 acres located in so and so by so and so who was the then NOCMA of so and so. Yes.
After this, Your Lordship, this particular land, the respondent number 4, he settled a part of this 5 acres land to the respondent number 5.
That is okay, but then where is the settlement by district council? So it means district council, so far the settlement is concerned, district council has no hand. Isn't it?
Yes.
That means it is only cancellation which you have.
No, that is not correct. What my learned friend is projecting the case, my lord. The case is this, my lord. An NOCU has been given by the NOCMA, my lord.
Yes.
On the basis of
that means that statement in the paragraph number 3 is wrong.
My lord, then a patta was issued by the district council. Then they came to know about the patta And that patta was under
Okay,
challenge.
just what do you say? Just it's okay. You see, your facts are totally. You have to, what you have said, what you have, what is stated in your petition. Nothing was given a land missing so and so by late so and so. You say Nokma is given.
Lordship, by the previous Nokma, Lordship.
Whatever it is, it was given. You say so. Now you are not mentioning about the settlement by district council.
The patta is on page 27, my lord. Of the
That is all right. Come to the amendments made in the rate petition. Mr. Day, we go by this thing. Facts we have to gather from the whatever stated in the rate petition. And if you read there, then you will not find that there is anything.
There are two, my lord. They specifically mentioned there are two that the district council has refused to cancel the patta.
That is all right.
We issue patta on the basis of the NOC issued by the
That is all right. That is all right. This court also was under this thing. Now, paragraph 3 made it different. Give it
Yes.
different meaning. Any, just oh yes, if the case that a portion of land measuring of 5 acres was settled, 5 acres located at NH 51 in West Garo Hills, Tura, was settled in favor of the respondent number 4. By the district council on the basis of no objection given by the then Nokma of Samingre King. Your drafting is not proper, then it becomes quite difficult. Where is the statement that a part of the land was given to respondent number 5? Okay. It's all right. It's all right. It's all right. It's there at para 7. Was there separate patta issued on the basis of that? Hmm? Okay. Subsequently, a portion of the said land, measuring over 2 acres, comma, 2 kathas, comma, 4 leches. You'll get the spelling. LESHA, this is will be para 7 in the spelling, okay? Was transferred to their son number 5. Stop. The petitioners, comma, who are the elders, who are the Maharis of the Samingekre, after coming to know of the aforesaid transfer, comma, filed an application filed a complaint, just as a, not application, but a complaint dated 11/5/2009. to the Secretary, Executive Committee, GHDC. This GHDC in the first paragraph where you say GHDC within Garrels Autonomous District Council, then you make it within bracket GHDC so that it becomes clear. Okay. And filed conversation and requested for cancellation and prayed for cancellation. Line patta issued to the private respondents. What is that quote of SASO, SASO? At para 10.
It should be settlement.
Your Lordship, in the main order also it's written SASO.
What is it? What does it mean?
44,
This is
page
settlement
44.
officer, my lord.
Must it file a complaint, shall be given date? Step further. Another complaint was lost to the same authority on 16/2012. Stop. Yes, no action was forthcoming, comma. A complaint, the petition, sorry, no, it was forthcoming, comma, a complaint was filed by the petitioners in the court of, you write it, SASO, huh? S, capital S, capital A, S, O, then within bracket, land in revenue.
Settlement officer.
This serial number is what? It's been complaint registration number or what?
Page.
50.
No, this is nothing. You see, like just say complaint was registered. I do not know what do you say in your thing, and then yes. This number, where from you get the number, and who allows this number?
Which?
That GD, that number before the revenue officer,
No, this
executive member, landed revenue. No, that is okay. This is what? This is registered as complaint or what?
Which number, my lord?
See, paragraph 10, you will find that this is said was filed in the court, revenue number, bearing number. So,
Oh, this is the case number, my lord.
yes, the case number.
GAGDC revenue 6, miss case
Yes,
of
so where is the complaint? This case number is not recorded here, isn't it?
probably it
The
has
court
not.
number, court number, you will get in the order only. Where do we get the case number?
Your
If
Lordship,
you
at
see the
page
typed
44.
copy of the order, there is no number reflected.
Your Lordship, at page 44.
Page 44,
there,
my lord, may kindly come.
first line.
The first line, no, number GAGDC revenues, miss case, 6 miss
That
case.
is okay. It should have been there in the typed copy also, isn't it?
The type copy has been done by them, my lord.
It is not there. Not there. Just say what was the thing? This is a problem, you know. It creates problem for the court.
No, my lord, may kindly come to the type copy page 50. Number, they have changed it. They brought number GAGDC revenue 6 miss case of 2016.
Where it is?
It is in the
Page 50. Where it is?
on the 7th line. 7th line from the top.
Number GHTC revenue.
Yes.
6 miskeys of 2016.
Yes.
Yes. It's the same number. You just say. Which was registered as. Yes. Number. Give a no number. GHDC dash. You'll find at page 50. Okay. I have underlined that part. GHDC dash REV stroke 6. Then MISC capital of 2016. Stop. The executive member after hearing the matter by order dated, is it 15/6?
15/6, Your Lordship, 2016.
15/6, 2016. Rejected the complaint of the petitioners. Stop. Against the said rejection, the petitioners filed an appeal in the court of the chief executive member GHDC Tura right number give GDC stroke revenue appeal number 7 within bracket A stroke C 2016. You'll get it page 58. Okay, page 58. Stop. The chief executive member. He is what? Respondent. CEO is the respondent number 2, isn't it? You filed an appeal before the respondent number 2, give a comma, then you say the CEO. Okay. And the first where you say the complaint, you say filed a complaint before the member revenue in charge, you said, na? There you just say before the respondent number 3, comma, then you say executive member in charge. Okay. Yes, where we left? Before the CM, isn't it? Byte number so and so. We have given even stop. The respondent number 3, respondent number 2. Byte order dated, byte impin order dated 14/3/2017. Declined to entertain. The appeal. On on the ground that he had no jurisdiction to try the appeal, and the matter and the appeal was required to filed before the Meghalaya Board of Revenue. Stop. Being agreed by the aforesaid orders passed by the respondent number 2 and 3, comma, the petitioners have preferred this writ petition before this court. Just say hard learned counsel for the parties. Oh, that is we have given at the top. Yes, it's not triggered. Just give a paragraph. Upon hearing the learned counsel for the parties and on perusal of the materials on record, it appears that the respondent number 2, while passing the order dated 14/3/2017, 14/3/2017, was misled by the provision of section 147 of the Assam Land and Revenue Regulation as adopted by the District Council, and came to a finding that the Court of Chief Executive Member has had no authority to entertain the appeal. Stop. The learned just say the respondent number 2, while passing the respondent number 2 while passing the order failed to take into consideration the Garo Hills Autonomous District within bracket you said Land and Revenue Regulation Amendment. You will find it at this book, this green book, page 298. Find to take into consideration the amendment of the Garo Hills Autonomous District Land and Revenue Regulation 1954, dated 25th November 1972, whereupon Regulation 4 had specifically laid down as under. Then we quote from here till the end. Okay. Give a paragraph. what emerges from the above is that as per the aforesaid amendment, any reference to the Board of Revenue in the Assam Land and Revenue Regulation 1986 should be construed as a reference to the chief executive member. Thus, the Board of Revenue becomes equivalent. Thus, the chief executive member becomes equivalent to the Board of Revenue, and hence an appeal under section 147 of the said under 157 of the 167 of the London Revenue Regulation is clearly maintainable for him. Stop. The paragraph in P of the paper, the order dated 14/3/2017, passed in revenue appeal number, passed by the number 2, revenue appeal number GDC stroke revenue appeal number 7 SC of 2016, that page 58 earlier, okay? Cannot stand scrutiny of law and hereby is set aside. The entire matter shall now stand remanded back to the restaurant number 2, who shall hear the parties and decide the appeal in accordance with law. Needless to say, while the restaurant number 2 takes up the appeal, he will take the appeal, he will also take into consideration the question of maintainability if raised by any of the contesting parties. Stop. It is provided that till an order is passed by the restaurant number 2 in this matter, the status quo with regard to the land as on today shall be maintained. Shall we fix a date for your appearance before the court, or shall we say that CM will issue
4 months, Your Lordship. Within 3 months.
disposal? But then what about your appearance? Okay.
Your
Just
Lordship,
stop. Give a stop.
Your Lordship, I have a small prayer, Lordship.
Yes.
Your Lordship, status quo cannot be maintained, Your Lordship.
Why not?
If this order is remanded back, Your Lordship.
So there was no stay order in your favor by the appellate authority. Nothing. It was never stayed at any point of time. So the position which was there at the time when you filed a complaint, same remains. What is the problem? Then you say an endeavor should be made by the restaurant number 2 to dispose of the entire matter within a period of Mr. Day?
4 months, well.
4 months.
Well.
There may be correction here, there may be repetition of words and all.
Only that question of limitation in open time.
Before that, what, where we said? Okay, we'll add it somewhere. Just where you said, needless to say, the question of maintainability. Somewhere you said, no, just needless to say the question of maintainability and limitation. Limitation also is a question of maintainability.
Only limitation, not maintainable. It is maintainable, but because 2017.
It's okay, the same thing, there is no problem in that. The question of maintainability and limitation. That is where you said only maintainability. It's a question of maintainability and limitation. Okay? You got it? There? Yes.
Item number 11.
Yes.
Your Lordship, here the state respondents are to come with instructions, Your Lordship.
What instruction?
Your Lordship, here there's a memorandum where the quota for the disabled, physically
My
challenged.
lord,
Yes.
before my friend begins, my lord, this matter was heard at length, my lord. Now, this is pertaining to, my lord, percentage of, my lord, reservation with regard to special category.
Disability quota.
My lord. Now, what had happened, my lord, at the fag end of the hearing, my lord, the petitioner came up with a notification saying that, my lord, the initial reservation was 2%. They came up with a notification saying that now it is 4%. So, my lord, with regard to that, my lord has directed the state.
Now it is 4% or it was 4% at that point of time.
At that point of time, my lord, apparently it was 2%, my lord.
Then?
So, my lord, they filed another, my lord, additional affidavit bringing into record the new notification. Probably it has a retrospective effect. I don't know that, my lord. Lordship had directed the state to obtain, the, my lord, instruction on that regard, my lord. My lord, very regretfully, I submit, my lord. Time and again, my lord, I had been sending my, my lord, notice to the concerned authority, my lord. Till now, I haven't received that clarification, my lord. So, my lord,
Do you have a copy of communication made by you?
My lord, my lord.
Yes, what do you pray? What do you say? No?
My lord, my respectful submission would be, my lord, last opportunity may be given to me, my lord. If not, my lord, the authority concerned, his physical presence may be required, my lord.
Then we'll require him to personally come and say before the court.
My lord, exactly. I
Okay,
have
then
put
you
my-
keep it for the timing. We'll just give him further one more distance. Yes. That's one number 4. And who is this one number 4? I mean, what for he is here?
He was the one appointed, my lord.
Oh, so they're challenging his appointment.
My lord.
So if the petitioner is to be appointed, then respondent 4 has to be ousted.
No, my lord. If 4%.
If that previous
Yes,
reservation
my
follows.
lord. My lord.
But then if it is 4, then. But then in such a case, why don't you take an instruction that whether you can accommodate the petitioner or not? That
Exactly,
matter
my
ends
lord.
there. Matter ends there.
My lord.
So why don't you do that?
I'll do my best.
You
my
should
lord.
be sympathetic to the person with
My lord.
disability, isn't
My
it?
lord is correct, my lord.
Then?
I'll do my lord.
If there is any scope of doing this, please do it.
My lord.
Okay. As prayed for by the learned GA and not objected by the learned council appealing for the petitioner. Further 2 weeks time is granted to take further to take necessary instruction in the matter. Further 2 weeks is granted to the GA to take necessary instruction in the matter. List accordingly. Yes.
Deeply obliged.
Item number 12.
Yes.
May it please your Lordship. Lordship, we're still awaiting instructions from the Ministry of Home Affairs.
So what is to be done?
Lordship, kindly grant us 3
What
weeks.
instruction is needed, Mr. Nagpur here?
This is regarding promotion from the post of rifleman Havaldar to the post of Naib Subedar. Now we're relying on one notification issued by Ministry of Home Affairs, which says
Okay,
that
this
17%
court has
has
asked
to be
the-
done. Yeah, Lordship.
Ask the secretary
Lordship.
to file this thing.
Lordship. That affidavit is required. That instructions is required.
Okay, as paid for by MS Sogra, landed counsel appearing on behalf of Dr. Anmojika, DSGA. Further, how much time?
3 weeks.
See, the thing is that court can give you time, but the only thing is that that you should ensure that you file it.
Lordship will file
Until
that.
unless you pursue it, then again problem.
Perhaps instructions first, Lordship. Then affidavit. They should receive
But then
instructions.
the court
first.
has asked them to file an affidavit.
Lordship.
So the order will go by that.
Lordship.
Because court has asked them to file an affidavit clarifying that aspect.
Lordship.
Whether Assam Rifles is a part of CPO or not, Central Police.
Paramilitary forces.
That is what probably, isn't it?
Lordship.
Okay. So further 3 weeks time is granted for filing affidavit in terms of order dated 60/2025 of this court. Stop paragraph list accordingly. Yes.
Highly obliged.
Highly obliged.
Item number 40.
This is that matter, my lord, where we have challenged the publication by which we were declared as willful defaulter, my lord, in violation of the RBI guidelines. We say that, my lord, there's a particular procedure laid down under the RBI guidelines which has a statutory force, my lord. That was not followed at the time of while declaring me as a willful defaulter. So they were required to place some instructions whether there was at all any proceedings carried out. They failed to do so. They, in fact, had categorically submitted before the Honorable Court that they do not have any records as such. My lord, if the other side is willing, my lord, I can start the matter, ma'am.
My lord, let it come after 1 week, my lord, since the senior counsel, Madam Tiangi, she's having some difficulties, my lord.
But then she was
After
here
1
in the morning, isn't it?
Lordship, she was here, but then she's having some difficulties. Can it come after 1 week, my lord?
I have no issues, my lord.
After 1 week, will be all right. After 1 week. The request made on behalf of MST Yangi, Standard Senior Counsel. Not objected to by.
Let's just one issue. Let's since that last order reflects, Millets, that they've refrained from, they've informed this honorable court that records are not available. For adjudication of this matter, Millets, I would make as a humble submission. Let them file an affidavit, bringing on record at least the fact, Millets, whether at all any proceedings were drawn up or not.
No, since they have not produced it, we'll do adverse inference. Why not?
Millets.
Whether they file affidavit or not affidavit, there is a court order, and that
they've said, Millets, that records are not available.
that will be good enough.
Millets.
You can basically point it out at the time of hearing.
We'll do that. Because there's a detailed procedure laid out as per
See,
the
if
rules.
they themselves they say they have not traced out the record, and if they fail to produce it before the court in spite of several orders, there will be inference that even at all if they say that rule was followed, we can infer that it was never followed. That is why the record is not there. Is it?
But I'm only saying, Mellows, that the proceedings itself were never drawn up.
That also will take a call on that when matter comes. Not sure. This matter after a week. Okay.
Right.
Deeply
Item number 15.
You have written not objected to by that petition.
Item 15, I am praying for some time today.
Why?
Actually, some personal issues. Not keeping well today.
The request made on made by Mr. P. Bhattacharya, Learned G. Not objected to by Mr. Gurung, Learned Counsel appearing for the petition on list of topics.
Replay.
Item number 17.
This matter, my lord, we can have it next week, my lord. I'm only to, my lord, in this matter, I'm only to satisfy your lordship whether, my lord, in the presence of the alternate remedy, my lord, whether I can still, whether this particular writ petition can
Please
still
check
be
the
made,
recent decision of Supreme Court
my lord.
in that aspect.
Right. I'm aware,
The
my lord.
Supreme Court is now more severe with that.
My lord, it has said, my lord, it cannot, it is not an absolute bar, my lord. But it is not an absolute bar.
certain decisions,
There are
further-
certain conditions which
Any-
I have to meet.
Anyway, you take those be when you take up the matter.
Lordship, next week means from 8 to 12, I am not available, Lordship.
So after 2 weeks.
After 2 weeks.
On the joint request made by the parties, list after 2 weeks. Yes.
18.
Mr. Pandey.
Yes. Will take bit time.
This will take a little bit of time.
Come back after lunch break.
Or we can have it some other time, Malaj, because this matter, otherwise also, Malaj, the urgency with this matter is no longer there. Because this pertains to disconnection of electricity, Malaj, so that aspect is done. Any date convenient, Malaj.
You 5 years you are without electricity.
Plant is basically shut down, Malaj.
So there is no urge on your part. So
Urgent-
whether matter survives.
No, Malaj, because we are saying that there is a statutory requirement, Malaj, to follow a certain procedure that was not done.
What is your grievance here?
The disconnection.
Disconnection. So it is not payment related issue.
It is payment related, Malaj, but that was disputed. That was already under consideration under orders of this court with the board, the MECL, Malaj. While that was going on, then this happened.
So far as the payment part is concerned, this court
The payment is not the
does
subject
not have
matter.
to go into that.
No,
So only the
the statutory part, Malaj. That whether there has to be statutory compliance
then
prior to.
if you are successful now,
Malaj.
what kind of order can be passed by this court at this stage?
Malaj, the disconnection would be illegal,
Restored.
Malaj, so
This
it will be restored.
Connection will be restored. That is the only relief. which
That
can
is
be
the only issue.
So Mr. Pandey can do it without the adjudication of this matter also if he wants.
Well, it's,
I don't think they'll be willing to do that.
No, if that you see relief is confined to that issue, this restoration of connection.
because there are dues of substantial amounts which are pending, so the reconnection cannot happen without payment of those dues. So that is the difficulty.
So when
Anytime, Manoj.
when it will be ready for you? When it will be
After 2 weeks, Malaj.
also they also say order early order on the joint request. Make after 2 weeks.
Right.
Yes.
Okay.
20.
Ready? Yes. So we'll come back after lunch break.
Yes, my lord. After lunch break, I have a difficulty, my lord. I have school obligation. So,
That cannot be a reason. Yes.
I have nothing to say. Okay, I'll make arrangement, my lord. After lunch break.
Are you sure? Anyway, are you have any objection to the prayer of
No objection.
adjournment?
No objection.
When you want it?
Next week, anytime.
After a week will be all right. You will have it after a week.
All right.
Just at the request made.
Yes. Lord, in any case, this matter, my lord.
So and so. Learned Council appearing for so and so. Just say list after 1 week.
No, the records will need to be called for, my lord, for
We'll just
adjudication of
see
this matter.
what for record is needed.
Not required, I think.
This is a Jimma matter, isn't
Yes,
it?
ma'am.
Jimma matter, and we are on a revisional jurisdiction. So we have to see.
All right.
Just see. Things will be confined. Unlike an appellate court, we may not go into every
All right.
aspect.
Onion.
Isn't it?
Exactly.
Yes. There are many matters. Acha, just call. If it is take some, then we'll take it.
Regular release to wrong.
Item 26.
It will come after this. Yes.
My lord, if my friend,
Will,
my lord, we can have it day after tomorrow, my lord.
My lord, after tomorrow, if it's not inconvenient, my lord, we can have it after lunch, my lord. It's a conviction matter, my lord. The
See, this court has no problems. If you are ready, the court
my
will
lord,
come. and say.
I am ready, my
Because
lord.
see, court has working hours. Court is bound to say.
My lord.
Court will not say never say. Court will not say.
Can you take up after the lunch, my lord? Then
It's up to you, as agreed by you. He is not ready to accommodate you, so court cannot help you.
My lord,
It
I'll
is not
remember.
this thing.
I'll remember
You
that.
see,
my lord.
the criminal appeal will not force him or.
My lord.
all right.
How long it will take, Mr.
My lord, 1 hour maybe at the most.
We'll come back.
My lord.
May please your lordship.
Yes.
My lord, this appeal is a conviction under section 304, my lord. 304 and section 304 part 2 of the Indian Penal Code, and also section 34 of the code, my lord. The judgment, my lord, that I'm sailing, it's judgment dated 06/11/2024, my lord. My lord will find that at page 124, my lord, of the arising out of Sada PS case number 38, my lord. Now here initially, now the little brief facts of this case is, well, on 20th March 2011, my lord, 20th March 2011, that is that was a holy festival celebration, my lord, and at Molanghat there was a dispute arose which pertain to a parking fees collections, my lord. The people who are alleged to be involved is my younger brother. Now there are two appeal, my lord, connected one. What we are doing is 26, that is Louis Dr. Dong, and the other one is Comius Dr. Dong. So before, my lord, I'm arguing for Louis Dr. Dong first now. So now I was not present at the spot, my lord. So there was a dispute between my younger brother and one person by the name of Krau Cooper Wanyang. They were allegedly sitting in the taxi. One Babyang, who is also a brother of the deceased. The deceased is rigid. So, because owing to some parking dispute, my lord, and a verbal dispute happened, which resulted into altercation with each other, and then resultingly the taxi was also broken, my lord. Now subsequently, my lord, the allegation is that after the altercation, my lord, a group of 7 or 8 persons, my lord, armed with hammers, armed with knives, they came, they assaulted the two brothers, my lord. One is Babyang and the other one is Rigid, the deceased now, my lord. That's how the
occupants of the vehicle. They were the occupants of the vehicle.
No. The occupants of the vehicle is Krau Cooper Wanyang. Krau Cooper Wanyang is not been charge sheeted. He has not been charge sheeted, my lord. Initially, he was also arrested. He was not charge sheeted later on because in a TIP, my lord, the witnesses failed to identify him. So that was the sole ground to discharge him. Now only the Comius Dutodong was identified in the TIP, my lord. Now the case around here is, my lord, before I take my grounds, my lord, before I take to the paper books, my lord, what are my grounds, my lord? My grounds are basically based on 3-4 points, my lord. Why I choose this ground is because in the impugned judgment, my lord, the point of determination, the issue was framed by the learned judge, my lord. The issue is whether the accused Comius Dong and Louis Dong, in furtherance of their common intention. Number one, common intention on 20/03/2011 at around 2 p.m. or 2:30 p.m. had severely assaulted Babyangjit Kurkalang and his elder brother Rijit Kurkalang at Molanghat, Shillong, where Rijit Kurkalang suffered serious injuries and later succumbed to his injuries, thereby liable to be punished under section 304/34 IPC. So this is the issue frame. Therefore, my lord,
this is the charge frame.
No, this is the points of determination. The charges were framed under 304 and 34, my lord. So this is the point of determinations by the special judge, by the learned trial court, my lord. Taking cue from this, my lord, I have before my lord, I wanted to address two key issues, my lord, as far as Louis Dotodong is concerned, my lord. One is whether the accused Louis Dotodong actively participated in the assault, number one. Number two is what is the reliability of the eyewitnesses identification, especially when TIP procedure against Louis was not completed, my lord. So, my lord,
Not completed means?
was not done, my lord. Against me, there was no TIP, my lord. Now, the star witnesses in this case, my lord, are PW1 and PW9. PW1 is the friend of the deceased brother, of the deceased person, and his brother, who started the fight. And PW9 is the elder brother who came to assist in the fight. So therefore, PW1 and PW9 are interested witness in this. Now, two things has come before my lord. What I wanted to address. I hope I am able to address what my mind says. One is TIP against me is not conducted. Second is I have been convicted based on two interested witnesses. And the law is very clear, my lord. When you are convicting a person on the basis of an interested witness, then there has to be a corroboration. That corroboration singularly is missing in this case, my lord. So therefore, my lord, I will just like to take my lord now to the FIR first, my lord. The FIR is at page 3.
Both of you have been convicted.
Yes, my lord.
Appeal is by only one person.
No, there are two appeal, my lord. The second appeal, 27, my lord, is by my brother. My lord has got the paper book. The paper book.
Yes. Yes.
The paper book, page 1 is the type copy, my lord. Paper 3 is the type copy, my lord. Page 3 is a type copy. May I read, my lord?
Yes, yes.
With reference to the subject cited above, I, Babyangjit Kurkarlang, would like to inform you, when I was collecting parking fee at Sora bus stand from a local taxi bearing a registration number ML04 7493, the people who were inside the taxi, around 6 or 7 of them, instead of giving the parking fee, they are making trouble and threaten me. After some time, some group came with hammer, stick, knife, and they severely assaulted me and my brother Rijit Kurkalang, resulting his death. Therefore, I would like to request you to take stern action against them as per legal, especially as I have lost my brother. So this is the FIR filed by the brother of the deceased, my lord. Now, my lord,
FIR was filed on the same day.
FIR was filed on the same day, my lord. Now, my lord, let us, I'll take to page 25, my lord. After the investigation, the final form was filed under section 173. That is page 21 is a final form, is a report under section 173, the charge sheet, my lord. The type copy is there. And then page 25. Page 25 is the story. 26 is the conclusion. Because 25, my lord, we have, on the last occasions, we stopped over here because there was some confusion in the manner in which the IO has reported. We have cross-checked with the legible copies. It is same. It's like this only, my lord.
What was the thing? What was the problem?
On 25, my lord, page 25.
Yes.
On 29/04/2011, a report was submitted to the Honorable Court of Additional District Judge, District Council Court, and the Honorable Court was requested to revoke the pre-interim bail of accused Sri Louis Totodong as he was not cooperating with the investigation or was needed for purpose of investigation. Accordingly, the Honorable Court has vacated the pre-arrest interim bail of Sri Louis Dotodong. Therefore, on 03/05/2011, Honorable Court of CGM Shillong issued an NBWA against the accused person, Sri so-and-so. It is also to be noted here that Sri so-and-so, who was under judicial custody, is the brother of Sri Louis Dotodong, who could lead to the police to apprehend Sri so-and-so, and he was taken into the police custody. So we'll just skip this part, my lord. And then, my lord, may I take my lord's attention to second last paragraph, the final fight took place from there. The final fight took place between both the parties, and one parking collector sustained injuries, and the other one fled away. After all the three people, I, Shri so-and-so, so-and-so, and Kraukupar Wanyang came to Cantonment Beat House at around 3:30 p.m. on 20/03/11, all and reported the matter. When Sri Louis Dudon heard the news at about 6 p.m. that the parking collector who was admitted in the civil hospital expired in the hospital, he took the mobile set of Commerce, Crow, and disappeared from the Cantonment Beat House. Sri Louis was forwarded to the Honorable Court on 29/07/11 and 26/8/2000. TIP was held in jail premise where the witness Sylvester Khongsit identified the accused. Sri was released on bail by the Honorable Court on 31st October 2011. The call details of mobile phone of Sri Louis and Wanyang, Kraukupar Wanyang, was collected on 05/11/2011, and the call details from the involvement of Louis Dodong and Commerce Dodong in case. Interestingly, Louis Dodong could not produce.
In case means what? What is the meaning of those?
Dodong in case. Involvement of and Commerce Dodong in case.
Means what? Anyway. Proceed.
Interestingly, Sri Louis Dutodong could not produce his mobile at the time of arrest, telling that he lost his mobile set. This is also an important point, that the deceased late Rigid Kurkalang was the only member who earned for family and survived young wife and a baby. Conclusion, my lord. At the end of the investigation, it is to be noted here that the case is registered under section 302/34 IPC, but during investigation it was revealed that it is not a case of pre-planned murder, but the crime has taken place under heat and sudden provocation. This is a case of culpable homicide not amounting to murder. The act has been done by injuring on body as it was likely to cause that one of the young men which is covered under section 304 of IPC. The weapon mentioned in the FIR could not be recovered. FSL report has not yet received. It will be produced in the Honorable Court after being received from FSL. The Kraukupar Wanyang was not identified in TIP by the.
What is the missing part?
This
is it is become like a puzzle, Mr. This court is not getting any meaning from the reading of this.
Well, the original also is like this, my lord. It's very difficult for us also. This page 20, the chart sheet.
This is a type copy of page 20.
Yes, my lord. With page 26 is the
page 20. Is it legible? Oh, God.
It is, my lord. We almost took 1 month to type this with those binoculars, my lord. Oh, what do you call this?
How trial was conducted with this?
I don't know, my lord. That's very unfortunate, my lord. But what I could gather, my lord, what I could try my level best, my lord, to whatever I could gather, my lord, out of these evidences, my lord.
That is okay, but then for this court,
yes,
it is very important that you should get the facts properly.
This is to be compared with the
we have
trial court, man.
record.
We have compared with the trial courts, my lord. It is somewhere like this only, my lord.
So what,
So, my
what
lord,
is this blank part then?
kindly bear with me, my lord. I'll try to.
No, that is no question, Mister. This court will definitely bear with you.
My lord.
But the only thing is that we should understand what we are reading.
Yes, my lord.
That is what is. We do not know, like, how to gather meaning from what you are reading.
My lord, we'll just skip this, but a very important point, my lord, which I was making. Can we, my lord, may I take my lord to the deposition of the witness, my lord, the two, because I am mostly, my lord, mostly my case revolves.
What is
and
the
if-
charge which was framed by the court?
Just check the charge. Just a second. Page 38, my lord. Page 38, my lord.
Yes.
Charge, my lord. I, Shri so and so, the two accused persons' name as follows. That on 20th/03/2011 at around 2 p.m. to 2:30 p.m., both of you, Shri Komias Dotodong and Shri Louis Dotodong, have severely assaulted Shri Rijit Kurkalang and Babiangjit Kurkalang at Maulonghat, Shillong, after a quarrel occurred between both of you and Shri Rijit Kurkalang and his brother Babiangjit Kurkalang. As a result of the injury, the victim, late Rijit Kurkalang, was admitted to civil hospital where he succumbed to his injury on the same day at around 6 p.m. And thereby both of you have committed an offense punishable under section 304/35 IPC, which is within the cognizance of this court. I hereby direct that both of you be tried on the charges. The charge is read over. So the charge has been framed under section 304 and 34, my lord. So, my lord, the first point, my lord, is that, as I was saying, my lord, this is based on conviction was based on the two witnesses, my lord, who are interested witnesses, my lord. So therefore, my lord, I will take my lord to the depositions of PW1 first, my lord.
Yes, yes.
The deposition of PW1 is at page 56, my lord. Page 56. My lord has page 56. Page 56.
Yes.
The name of the witness is Sylvester Kongsit, my lord.
Who is he?
Sylvester Kongsit is one of their friend, my lord, who accompanied to the place of occurrence, my lord.
He was with the collectors, or he was
with the collectors, my lord. I know this case. It was Sunday, Holy Festival, in the year 2011. The younger brother of the deceased called up his own brother, who was also with me at that time. After that, we went to the spot. The incident had already taken place, and 4 or 5 people came to us and started assaulting both the brothers of the deceased, but they did not do anything to me. I can identify only 1 out of the 4 or 5 people who had beaten up the brothers of the deceased on that day, and the accused is present in the court dock today. The witness has pointed at Louis Dotudong. Cross-examination. It is fact that in the year 2011, there were many people celebrating Holi. When the deceased brother called up his elder brother by telephone call, we were both in a marketplace. It is a fact that I was not present at the time when there was a fight at the parking lot.
Which parking lot it is?
This Maulonghat. It is a fact.
Maulonghat means the down one.
Yes, sir.
Not that upper one that you. Okay.
Yes. It is a.
There are 2 parking there, isn't it?
It is also called as Ratsang parking lot.
It means the down one, the which from
My lord.
Anjali side, if you come and then you get it. Right. Yes.
It is a fact that the deceased, my lord has not page
Yes, yes,
57.
please, yes,
It is a fact that the deceased is my friend and the deceased during his lifetime is a member of the KSU. It is a fact that both the deceased and his brother were drunk at the time of the occurrence. It is a fact that I am not working in the parking lot for collecting money. It is a fact that during the fight, they were running here and there, so I cannot identify the other persons, but I can identify only one. It is a fact that the PS is nearer, but I could not inform as because I was in shock due to the incident. It is a fact that the deceased was still alive when the police carried him to civil hospital. It is a fact that when the body of the deceased was carried to the hospital, I did not accompany him. The fight has occurred due to the heated quarreling about parking fees, and I do not know what is the parking. It is not a fact that I have deposed falsely before this court. Now, to one thing, my lord, here he says that I identify the accused person who assaulted. Now, he never said with what weapon I have assaulted. It's a very vague kind of statement, my lord. And now, my lord, my lord, I'll just take to a TIP first, my lord.
Now, what you want to say that this person, though he has said, he has
Yes.
identified
Yes.
the accused,
Yes.
but then he did not say that what weapon was used by him to assault the victim.
No, no. What I wanted to say, that is also one of the point.
No,
What
but
I
then
want
just say what is there.
what I
Because-
wanted to say is, my lord, he said I have identified. Now, where did he say that I have identified? This is in the court. When the accused was brought in the dock, TIP, during the TIP, he never identified this man. Why TIP? Because Louis was never produced. So now, the law is, you cannot convict somebody just because the witness identified him in the dock without prior TIP. So that is the law. So here, my lord, I'll just take my law to TIP. TIP is page 99.
But then you said no TIP was conducted in respect of the accused.
Exactly, my lord. That's the point. Now there are five, six of them. Five, six of them. They were saying that it's a day of a holy celebration, and it is in the noon. There is a fight happening. Five, six of them all running scatter helter, my lord. And he said, I saw Louis Dutodong. But he never said, so since he is a star witness who is supposedly have witnessed, means ocular witness, and when there is a group fight, what would the prosecution could have done? Could have taken for the TIP first. He never identified in the TIP. Why? Because the procedure for TIP was not concluded in respect of Louis Dutodong. The only time he said, I identified, yes, I recognize him, he was one of them in the fight, was in the court. My lord, in this aspect, my lord, I was just taking my lord to page 99. That is the TIP, my lord. Page 99. My lord has got it.
Yes, please.
Page. So I will not read the front part, the note. My lord can come to the table. Date and time of conducting the identification is on 7/4/2011. The place where it was conducted was district jail. Name of the identifying witnesses, my lord, are Babiangjit Kurkalang and Sylvester Kongsit, he is the one. Name of the suspects were Kraukupar and Komias and Louis Dotudong. Louis Dotudong, and my lord will just go down to see. It says that this part I'll just read. Kraukupar, Louis, number 3 is Louis. Court, bail by District Council Court, Shillong, by order dated 30th of 03, 2011, found absent today. Which means on the day, which means TIP in respect of Louis was not conducted, was not completed. Which means this.
Whether prosecution is disputing it, or was there any finding by the trial court?
Yes.
That he was identified in TIP.
My lord, that is a problem, Lord. That is a problem.
Just tell us directly. Was there any order by the trial court, or any finding by the trial court which says that the accused Louis Dotong was identified? Is there any finding by the trial court in the impugned judgment?
My lord, that is exactly the point, my lord. Because the court did not the court did not take into consideration this aspect, my lord.
No, just a minute. Did not take into consideration means whether the court has given any contradictory finding.
Contradictory finding, my lord, it has given contradictory finding. Why? Because he took it the statement as a gospel truth from these two.
Wait. We are not. You are just trying to mix it up with your submission.
My lord.
This court is not on that right now.
Yes.
What we want to know the facts as it stands.
Yes, my lord.
Now you have showed us this TIP to show that your accused was not present on that day, isn't it? You are pointing out this page 99, isn't it, for the purpose of that?
Yes,
You want to establish that Louis Dotong was not present.
Louis
for TIP.
Yes.
Is it that what you are contending here?
Exactly, my lord. Yes.
Now, the question this court is posing is that whether trial court has given any contradictory finding to this,
My
saying
lord,
that no, he was identified in TIP.
my lord, just give me a second. I'll just take to the finding. I'll show to the finding of the court, my lord.
Why, you have not read the judgment?
No, my lord, I have read, but
No,
it's
since you are raising,
long.
see, this is your point of argument, isn't it?
Yes, my lord.
So just tell us whether there is a contradictory finding.
I'll just pinpoint to that, my lord. I did not mark that, my lord. Just give me a second, my lord.
Yes.
My lord, what had happened, my lord? He was absent because he was absconding, my lord.
Anyway,
Subsequently, my lord.
Anyway, that you say.
Second TIP was held.
You say it when you reply. Please note down which point is these things. Kindly you note down and then you reply.
Yes, ma'am.
Let him go in his way.
Just find out that part. But that's the. Sometimes this is the.
Now the decision of Apex Court.
Yes.
Which you said.
My lord.
That it was held that identification in the courtroom is no identification in law.
My lord.
Isn't it?
Yes, my lord.
Now, does that proposition come when the identity of the accused could not be disclosed? So whether that identification can be equated with an identification where a witness points out to the accused saying that yes, he is the person who has committed the crime.
My lord.
Is there any difference between these two
My
kinds
lord,
of identification?
I will just read out one of the judgment, my lord, where the Honorable Supreme Court in these circumstances have held, my lord. This I'll just pass on.
Anyway, before you come to judgment, you just finish your thing. Submission so far as 1990 is concerned.
Yes, my lord. So, my lord,
come to the law points after. Please note down your points and then give law decisions accordingly after review.
My lord.
Finish taking up your points.
So, my lord, my point was that.
So there is no contrary finding by the trial court with regard to TIP.
My lord, that I'll just point it out that later on, my lord. So my point was that number one, that no valid TIP was conducted against Louis Dong, my lord. No valid TIP was conducted. Now the second point that my lord was just posting me a question that I'll just answer, my lord, in this way, my lord. In court identification, my lord, without prior TIP, it's a weak evidence, my lord.
No, that is all right. That is understood. Kindly try to. I do not know whether court is able to communicate to you.
Oh, my lord.
See, identification just for the purpose of finding out who has committed the crime.
Yes.
Okay. Say supposing two groups fight.
Yes.
Something happens, and then it is not ascertained as to who were the part of groups.
Yes. Yes.
And then you find out, you catch some person, some accused, and then conduct a test to identify that these men were there.
Yes.
Mr.
Yes.
Yuvan was there, Mr. Gurung was there.
Yes. Yes.
This is kind of one identification which is conducted during the time of investigation to find out
Yes.
who is the accused.
Responsible.
Now, second part, the identification of the accused
Yes.
for the first time in the courtroom.
Yes.
Now, if it concerns,
Yes.
it is concerned, you see, like to aid the investigation to say that this person was involved, or if it is only for the purpose of showing that this person had a role in beating the victim,
Yes.
that maybe stands in two different footings.
Yes.
There may be a case where identification may not be required. It happens, the accused is picked up, there is a allegation against him in the FIR, he is picked up.
Yes.
Okay. Now, identification there is required just to confirm his role. But then, whether he was there or not there, for determining these, that identification is not needed. Now, you are a man who is named in the FIR, isn't it?
No, my lord. My name is not there in the FIR.
Your name is not there.
Not in the FIR, my lord.
So, this charge sheet doesn't say anything as to how you are connected with the case.
The charge sheet doesn't say as to how I am connected with the case, my lord. It is only based on the statement of these two PW1 and
That is in the court. That is in the court, but the
PW.
trial. But then, so far as the charge sheet is concerned, the charge sheet doesn't say that which manner you are found involved in the matter.
No, that part is, there's a very vague finding, my lord. There's no specific finding, and in fact, my lord, even in 164, my lord, even if you see 164 statement, my lord.
Yes.
164 statement is at page 55, my lord.
Who's 164 statement?
Of the same of this same person, my lord, of Sylvester PW1, my lord. This is also again.
This 164 is also there.
Yes, his 164 also.
Anyway, right now you are making submission. We should not mix up the things, otherwise you will get confused.
Yes.
Okay.
So, my lord, now, just coming back to the TIP again, my lord.
Yes.
TIP again, my lord. Now, the scenario is that there were 5-6 people.
When this TIP was conducted on 7th. Yes. Okay.
Yes, there were 5-6 people, my lord. 5-6 people means from the other side also there will be a group, my lord.
That we
No,
do not know anyway.
there is a group fight going on, my lord. There's a group fight going on now. Now the TIP, my lord, as my lord rightly says, my lord, he is a star witness. So now, who has committed that assault? Who has hit with what? In what manner? And because I can be liable for the overt act of my individual. There may be a fight. I may be present there. I may be, who knows, I may be trying to separate them out. I may be pushing and pulling. It may happen. But now, this man, Sylvester, who is supposed to be present there, never stated that he saw me hitting, punching, kicking, or hitting with some kind of weapons. This is also a very vital point, my lord.
So according to you, PW1 does not say
yes
the role played by you.
Exactly, my lord. Does not say that all, my lord. Now, my lord, in that, my lord, shall we go to, may I take my lord to PW9's statement now, my lord? Because these are very important witnesses from the point of prosecution. And
no, what about 2, 3, 4, and 5?
2, 3, 4, and 5, my lord, they are merely.
No. Do you want to say that they are not? They are relevant.
My lord, these
are not relevant. If you say no relevant, then we'll skip.
These are not relevant, but they are no hearsay, my lord. Also.
So we will say that these are not relevant according to you.
According to me, they are not relevant, my lord. So PW9, my lord. PW9 is page 68, my lord.
All other 2 to 8, not much relevant.
They are not much relevant, my lord. 228, my lord. Medical officers, that I'll come back, my lord, later. But let us go first these two because they are star witnesses, my lord.
So it is not that they're totally irrelevant.
This is a
This
doctor's.
court has to make a note of your submission. That is the problem, Mr.
No, my lord, because
Either you say this or you say no, they are relevant. So,
my lord, doctors, my lord, doctors in my point of view, my lord, doctor is PW7, my lord, may have some relevance, my lord.
doctor may have relevance so far as the injury sustained by
Injuries
the
are concerned, my lord.
victim is concerned
Yes,
and the
my
cause
lord.
of death is concerned.
Yes, my lord.
But then a doctor can never say who is involved.
Exactly, my lord. So for that, because that's the reason why I am taking my lord to PW1 and PW9. Then only I will come to the injuries, my lord.
Yes.
Then the PW7 will be relevant for that, my lord. Okay. So, my lord, PW9 is page 68, my lord. Page 68. May I read, my lord has to?
Yes, just wait. Yes, please.
Uh, I have received summon to appear before this court today, and I am also aware as to why I have been summoned before this honorable
He is
court.
a complainant?
My lord?
He is a complainant?
Yes, he's
Is
a
he the
complainant.
complainant?
Yes, he's a complainant, my
Yes.
lord. I have been summoned before this court with regard to the murder of my brother, late Rijit Kurkalang. On 20th March 2011 at around 2:30 p.m., while I was collecting the parking fees at Anjali parking lot, I saw two boys sitting in a local taxi consuming beer. I asked of the parking fee from them, but they refused to give any. Since these two boys were refusing to give the parking fee, I called my brother Rijit Kurkalang. After some time, my deceased brother came to the spot and we had a quarrel with these two persons who were not paying the parking fee. And after some time, both these persons left the place, leaving the local taxi at the spot. Later on, after some time, these two persons came back again, along with other people who were armed with hammer, iron rod, dagger, and assaulted us. And out of fear, I managed to flee from the scene, but these people continue to assault my brother, and after assaulting him, they fled away from the place. After I have fled from the place, I went straight home and informed the relatives, and later on, we were informed that the police had reached the spot and saw my brother, who was badly injured, and took him to civil hospital Shillong for medical treatment. But unfortunately, later on, he succumbed to his injuries on the same day. Later, we will receive a phone call from our friends who were working as parking lot attendee, and they told us that my injured brother has been shifted to civil hospital Shillong by the police. And on receiving the said information, I, along with my relatives, immediately rushed to civil hospital Shillong. And when we reached civil hospital Shillong, he was bandaged and was conscious, but later 10 to 20 minutes, he succumbed to his injuries. Later on, I had lodged the FIR to the police at Cantonment Beat House. The FIR was written by the then in charge, Mr. Singh, on being narrated by me, and after being satisfied, I had put my signature on the FIR. Exhibit 5 is the FIR lodged by me, and Exhibit 5 by 1 is my signature. I also remember that I also asked to identify the accused person. An edification was conducted at the district jail is Khasil, and the same was conducted in the presence of one magistrate. In the said test identification parade conducted at the jail, I was able to identify both the accused persons, and these two persons were also present in a courtroom today. Witness pointing to both the accused persons who are standing near the courtroom today. Exhibit 6 is the identification of suspected report. 6 by 1 is my signature. I do not remember whether my statement was recorded by the magistrate since it has been so long. Cross-examination, so and so, I had cross-examination. I had drafted the FIR. I went along to the police to lodge the FIR. I'm working as a parking attendee on the day of the incident had occurred, and at the time we charged rupees 30 for the whole day parking. On the day of the incident, I had asked the parking fees from the person who is present today in the court since he was sitting in the vehicle, and there was also another person whose name I do not know. I do not know whether Comius was a passenger or a driver, but he was sitting inside the vehicle. Suggestion, counsel suggested, as per the statement of Sylvester Khongsit during his cross-examination, had stated that you and your deceased brother were drunk. Answer was, I do not agree to the said statement. I and my brother were not drunk on the day of the incident. It is a fact that there were many people who had assaulted me and my brother, but I also like to state that clearly the two persons who are present today in the courtroom. At the time of the incident, my elder brother was at Foreign Market Bazaar, Yodo, and I went to call him from there. It is not a fact that I have stated today is what I have seen. Oh, it is not a fact. What I have stated today is what I have seen, what had happened to us on that day. It is not a fact that I was in the custody of jail at the time when the TIP was conducted. Now, my lord, even this witness has even contradicted so much, my lord. Right? FIR. He said the police drafted FIR. Cross, he said, I drafted FIR. It may not be material, but what I wanted to build up the case, my lord. And he says that TIP was conducted, and yes, I have identified both of them. When the
your cross-examination is very limited to that effect.
Well,
your cross-examination
yes.
even has not gone to show
Exa-
that even you were not present there or not.
My lord,
See,
yes.
at least one thing is here, if you go by this evidence,
my lord,
irrespective of what comes out, whether you have taken part in assaulting the victim or not,
my lord,
you have not denied your presence in that area.
my lord,
So you were there.
my lord,
you have very, very cryptic cross-examination.
I understand, my lord. I go down. I've read this, my lord, but I am.
No, we can understand you are to argue in a given situation.
My lord,
we know.
My lord.
But then,
But here also, my lord, now the relevance, the reliability of this witness, my lord. As I said, he's the witness. He's one of the interested witness here, my lord.
what is the law? What does it say that the evidence of the interested witness should be totally discarded?
No, my lord.
No, it is for the court. If it requires support, then it should look for support.
My lord,
but then what it requires is that
yes,
that what your cross-examination reveals.
My lord, when the court is considering the witnesses or the depositions or the evidence of interested witness, my lord, there has to be a corroboration. The corroboration of third neutral witness, my lord. This is singularly missing here. That's what my point is.
So you want to say that in a case,
my lord,
where there is no independent witness,
yes,
and conviction is made,
yes,
basing on the evidence of interested witness, this cannot be sustained anymore.
That cannot be sustained, my lord. This is my point, my lord. Because now, my lord, and even this gentleman also, again now, my lord, now before I go to the medical witnesses, my lord, he said they have come with hammer, rod, knife. Who was holding? Was it that? Yes, I saw these persons are here.
But then when Section 34 is involved, how much help this argument would make?
My lord,
you know, in a group fight, though your individual role
yes,
is not clarified, but then if it is shown that you are part of a group,
my lord,
which have
I'm sorry to cut. Yes,
which are assaulted, then your part also becomes this.
My lord, section
law doesn't need any separate witness to pinpoint particularly your participation.
Given in this case, my lord, I've just read it in a bit and pieces, whatever we could gather, my lord. What did the investigating officer said? the investigating officer said there was no pre-planned. The fight has happened because about heat and a moment. So therefore, my lord, attracting section 34, which I believe, my lord, is a common intention, does not arise at all, my lord. The prosecution himself, investigating
See,
officer,
common intention and criminal conspiracy.
my lord.
There are two different aspects.
Exactly.
When there is a conspiracy,
Yes.
there may be an assumption that it was planned before.
Yes.
But then intention
Yes.
can arise then and there.
But the
you are playing in a football field.
Yes, my lord.
Suddenly fight erupts. And then two groups. There is always intention that one group will resist another.
My lord, but then my lord, then have to meet the then you have to meet the prior meeting of minds first, my lord. When there's a hit,
That is 120B.
my lord.
In 34 where it is.
My lord, there is my lord, in this case, my lord. Suppose now, my lord, as my lord rightly said, that we're having a football match. Somebody kicked my leg. My friend came and pushed him, and there was a fight. So we never knew that he's going to kick, and if he's going to kick, I am going to come and punch him.
Do you want to say it means you want to say that section 34 also?
That's not a trick in my case. My lord.
There
There is
has
no
to be-
evidence.
There has to be some sort of
Intention, meeting of mind.
Meeting of mind.
There has to be a meeting
prior
of
to
mind,
the-
my lord.
Prior to the occurrence. of
Yes,
the
my lord.
incident.
There has to be a meeting of mind, my lord. Because it talks about a common intention, my lord. And in this case, my lord, there is no evidence of common intention, my lord. That's not what I said. That is what that is IO said himself. So now we'll have to believe what IO said. And none of the witnesses also comes to that evidence to say that there was a common intention. Therefore, section 34 does not attract at all, my lord, in this case, my lord. Now, how did this sudden fight happen?
What about the evidence which says that you left and you came back with a group? And that there is no denial of that evidence in your cross-examination. You have not even conducted single cross-examination in that line. How will you refute that? Will it not that statement will stand against you?
My lord, that's the statement of, again, my lord, I'll come back. That's a statement of the interested witnesses, my lord.
Okay, that we have taken note of.
Yes,
Anyway, it's okay.
So, my lord, even this gentleman, my lord, I've never said anywhere, my lord, it is my overt act, my lord. It is my overt act. He never said that he saw me hitting with any kind of weapon, my lord. Any kind of weapon. I cannot, at this stage, I cannot improve my case by saying that, no, I wasn't there. I have to argue.
Exactly. No, that is understood, Mr.
I have to argue what is before me.
No, this court
Yes, my lord.
knows it very well.
My lord. So, my lord, my point is, my lord, reading these two evidences, who was supposed to be ocular.
Tell us one thing.
My lord.
Say, supposing in this kind of incident, though your individual role
Yes, my lord.
to the assault
Yes.
is not
Yes, my
proved,
lord. Yes, my lord.
but then does your presence in the scene of occurrence makes you liable to explain certain situation under law? Though in a criminal law, it is not for the accused to prove his innocence.
My lord,
But then is there any kind of law which says that when your presence is there, you also to some extent required to explain the situation?
my lord, mere presence, my lord, mere presence in the riot, or being a part of the group, my lord, in a riot without your overt act, my lord, does not attract a.
So according to you, no explanation is called for you.
No explanation is called for, my lord. I can be present there, my lord.
No, presence is another thing.
Yes, my lord.
You have been made an accused.
I've been made an.
Fact of being mere presence and fact of being made an accused.
Yes, my lord. My
Okay.
lord.
Now,
Oh, I'm sorry. Yes, yes, my lord.
so according to you, the law does not require any sort of explanation.
My lord, in 313, 313, I have explained the situations, my lord. In 313, I have explained the situations, why I am there, how I am there. This I have explained very clearly, my lord. Now, my lord, in order to be, I may be there, I may be present, but my lord, there has to be there has to be an evidence, direct evidence linking me to the death of this person. Then only, my lord, I can be arraigned or I can be accused and I can be jailed for and I'll be convicted for. Where is that link? That's a question that I ask myself. That is the reason why I said, my lord, conviction, section 30434 against Louis Dudorong is wrong. Because there is no evidence directly linking me to the death of the death of the disease regime. So that is where I stand, my lord.
So according to you, that even in PW 9 statement,
yes,
there's nothing to link you with the commission of the crime.
There is nothing to link me, my lord. It's a statement, very vague statement given by an interested witness. Why? Because unfortunately, he lost his brother in this scuffle. And a scuffle that happened between
Why did he pointed? Why did he accused you? Was there any enmity between you and him?
My lord,
was there any question raised the trial that this entire accusation is the outcome of the enmity between you and the complainant?
No, my lord, those kind of questions were not.
It was
not come forward,
yes,
my lord.
Yes. So that plea is not there with you.
It is not there with
because
me,
otherwise normal situation.
Yes.
You will not do anything bad to me, or I will not do.
Yes.
Until and unless we have some sort of grudge.
Yes. Yes.
So that is.
Yes. The only why he took my lord. The only point that they suspected me, my lord, is because if my lord will see the MVI report, my lord. MVI report, my lord, at page 90.
Just a minute. Yes.
MVI report, my lord, kindly look at this MVI report at page 90. MVI report at page 90, my lord. Damages. This is the MVI report of the taxi, my lord.
Yes.
Front windshield glass and LH damage partner. Front windshield glass and LHS RR window glasses were damaged, my lord. Now, my lord, I and Krau Cooper and Komias Dotodong, we went to the police station to file an FIR, my lord, for assaulting my brother and Krau Cooper and damaging the windshield, allegedly by the complainant Babiang and his friends, my lord. We went there, my lord, and subsequently, while we were in the police station, my lord, we came to learn that one of the person in the parking lot, my lord, succumbed to his injuries, my lord. Therefore, since we were there in the police station, that is where the suspect occurs against me also, my lord. This can be a very vague kind of thing, but just trying to explain, my lord, not trying to suppress anything, my lord. This can be one of the incident, because of the IO also says that I ran away from the police station. Saying that running away from the police station, that was very wrong for him to say that also, my lord. There is no evidence to say that I ran away from the police station.
What type of evidence you want in such a case?
I'm sorry.
Who should come and depose that you were running from the evidence? If you are in your custody of police, or if you are there in the police station, it is only for the police to say. Other unknown person will never say that.
Well, this is because now, my lord, why The police have roped me.
Do
into
you want to
this.
say that IO statement should be outrightly rejected?
My lord, look at the manner in which the investigation is
Just tell
conducted.
about law. Do not take it to the
Ma-
context of this. See,
Yes, my lord.
now, see, the query by the court doesn't mean the
My lord.
court is against him. That is never ever thing.
Yes, yes. No, 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 not at all.
These
my-
are queries so that you see, like, you clarify these situations.
Yes, my lord.
Now, if you say that there is an allegation by the police that you were running away from the police station. Now, you say that that is only there in the IO statement.
Yes.
Then, according to you, what would be the best statement in this kind of situation? Whose statement can be regarded as the best statement? Because it's only for the police to tell. Nobody else will come and tell.
Yes, my lord.
Then,
So I was just saying, my lord,
now,
that
what matters is that
yes,
those kind of statement is dealt with by which manner in your cross-examination.
yes,
That matters.
that matters, my lord. Yes. So, my lord, as per the witnesses and the evidences connected with the case, my lord, there is no direct evidence linking with me to the
Yes.
to
Yes,
the offense, my lord.
court is noted it.
My lord. So therefore, my lord, connecting me to, therefore, my lord, mere presence, or I'll just take back that one, my lord, because sometimes some words like
No, you have said already that mere presence in the scene of occurrence, or the place of occurrence, will definitely not make you guilty of a crime, isn't
my
it?
lord, my lord, yeah, that is this.
It is after all your vehicle which was damaged. So your presence was very much normal,
yes, yes, my
natural.
lord. And
But then
nobody.
just because you were present doesn't mean that you have assaulted somebody
Yes.
and the person has succumbed because of
Yes.
yours.
And the important is the fatal blow, my lord. Nobody says that I gave a fatal blow.
Mr. Yuvin, there, see, like, do you verify that part of the thing?
My lord.
When assault takes place in group, how much this individual action
Yes.
would matter?
Yes.
When your participation in the group is not disputed. Just see that part, you verify.
My lord. My lord.
There, probably the action of each and every person is not required to prove it. Me and you, we are together, we go somewhere, we pick up a fight, I give a blow, the person dies because of that. But then you were also there holding you or maybe pushing him somewhere. You may also be charged for murder.
My lord, in that case,
There may not be necessary for the prosecution to say that no, the death blow was given by such and such person and he was not.
my lord, according to the statements, my lord, 5-6 of them, these people, they said, 5-6 of people came, these people, plural, were assaulting. So 5-6 people should have been convicted.
But then if not convicted, then your conviction also cannot be sustained in law. Is it your argument?
My lord, what I mean to say is now the prosecution's lapses, my lord.
That is
Prosecution's
understood.
lapses.
That is understood, Mr. Yubin.
My
Only thing is that what we are concerned with that,
Yes.
with whatever the materials on record or the evidence,
Yes.
we have to determine only whether that is good enough
Yes, my
to
lord.
sustain conviction.
Yes. Yes, my lord.
Now, what could have been a better investigation or not,
Yes.
and whether you see, like, those 6 or 7 persons were required to be convicted or not, may not be very much relevant for the purpose of proving your innocence.
Exactly, my lord. Yes. So now, my lord, I'll just come to the medical report. Why I wanted to show the medical report is it only shows a. Where's the medical report? The statement of the doctor. Just show the statement of doctor.
There is no conflict of interest between both the accused, two appeals.
They are brothers.
It will not be, that is okay. But then, so far as you are concerned,
There won't be any difference.
any clashing argument.
No, my lord. Because in my humble submissions, my lord, both of them are innocent.
Now, if your submission, if it concerns to test or identification parade,
my lord,
you were not there, you have not been. But then, so far as the other person is concerned, you were there, he was identified.
Yes.
Now, whether the same argument will serve the other person's or you will have a different set of argument for that other person.
My lord, today I'm arguing for Louis, my lord. Today I'm arguing for Louis, my lord. I may have a different set, but not.
See, if this matter
Yes.
arises out of the same trial,
My lord.
court may not have to pass two different judgment for two persons. One
Except,
judgment may take care of one, provided
yes.
your submission. Which way it goes, you see, like that.
Except for the point, my lord, the TIP, my lord. Except for the point, the TIP, my lord, all other grounds of my
Are common,
submissions will
are
remain
common.
covered, my lord. Except for the TIP, my lord. Because then for commerce to down.
So you can say that TIP, ground of TIP is an additional ground available to the present appellant.
Yes, yes, my lord. So the medical, my lord, post-mortem. The post-mortem report is, my lord, at page 84, my lord. And
yes, where's the type copy?
The typed copy, my lord, is page 87. Page 87 onwards, my lord.
Yes.
So the wounds, my lord, the second part.
Yes.
The second column, my lord, external appearance, my lord, wounds.
Yes.
Bruise right eye, stab injury, then punctured nipple, then mark on the neck dissections, my lord, abrasion, laceration, my lord, all this.
You are reading which table page?
My lord, that's page 87. That's a typed copy, my lord, post-mortem. And the second column, external appearance, my lord.
Yes.
Give me the statement of the doctor.
Wounds, position, size, and character.
Yes, my lord.
Then bruise right eye.
Yes, my
Number
lord.
2, stab injuries.
Yes, my lord.
Puncture 2 into 6.8 centimeter.
On the right back, size 12 centimeter from back.
Neck, midline below.
Below.
Scapula.
Scapula.
Yes.
And then the bruise positioned, size and nature. Step puncture injury 4 into. So deep abrasion and all this, my lord.
Yes.
These are all the injury marks found on the body, my lord.
And what is the opinion of the doctor?
The opinion of the doctor, my lord, would be at
Page 89.
the last part, my lord. More detailed description of injury or disease.
Yes.
As this, my lord has got.
Yes.
As described, this is a body of a male body in regio mortis, HOK.
Rigor mortis. Anyway, these spellings are it's not typed out properly.
My lord, this is one of the case where we really struggle, my lord. On 20th/03/2000 at about 3 p.m., he was assaulted by unknown persons armed with weapons at Maulanghat. He was shifted to Civil Hospital Shillong, succumbed to his injuries after some time due to profuse bleeding from the head and chest wounds caused by stab injury to the chest wall puncturing the left lung, and the head injury caused by a blunted heavy object, hammer, etc. So now, my lord, this is the injury caused to the because of which, my lord, he succumbed to injury, my lord. Now, my lord, where is the evidence linking me to stab, to hit him with a hammer, to hit him with rod? Where is that evidence?
No, but then this postmortem doesn't mention anything about hammering. It speaks about stab injuries.
With a blunt and heavy object, hammer, etc. The last part.
Acha, blunt heavy
Yes.
object.
And now, the most important thing is, my lord, where is the murder weapon?
Is it fatal for prosecution case?
My lord, when, my lord, the evidences, the evidences are such, my lord. There was a weapon used to cause the death of somebody, my lord.
What is the position of law? The failure of the prosecution to identify and seize the murder of the weapon of murder.
It's not fatal, my lord. There's a judgment to that effect, my lord. It's not fatal, my lord. My lord, now, in this, my lord.
So according to you, postmortem report.
Yes, my lord.
Says it beyond reasonable doubt.
Yes.
The victim was assaulted.
Yes.
By a knife and by blunt object, hammer, etc.
Yes.
But then the prosecution has not tried to find out any of the weapon.
Yes.
And so when they fail to do it, definitely you say like
the benefit of doubt must go to me, because you can. What is the law in conviction, my lord? You must prove beyond reasonable doubt.
Exactly.
Now there is no forensic evidence, my lord, connecting the accused directly to the to these injuries, my lord. There is no forensic.
So your case, basically, your conviction has to be, it is dependent on the version of the ocular witnesses.
Yes.
That is not dependent on circumstantial evidence.
No.
Because postmortem report
Yes.
cannot show you involvement.
Exactly.
There is
my
no
lord.
seizure of
Yes.
weapon of crime.
Exactly, my lord.
Nowhere your fingerprint or anything is found
Nothing,
anywhere.
nothing at all.
Isn't it?
Yes, my lord.
So there is no scientific evidence against you.
There is no scientific evidence against me. The ocular evidences, so-called the ocular evidences, are the best evidences. Very vague statement has been given. No direct linking of me to the offense. My lord. I may be present. I may be present there. But there is no linking me to the overt act. So therefore, my lord, finding me of committing this heinous crime, my lord, convicting me under section 304 it's error in law, my lord. So that is my submissions, my lord. Now coming back to the TIP, my lord, I just wanted to place one submissions, my lord.
Yes.
Just submission. Where is judgment? This one. This judgment. This is a very old judgment of 1970, my
Have
lord.
you made any compilation or?
Actually, I've given a list of books, my lord. A list of books, my lord.
You do not need to submit any compilation.
My lord, I'll just show this one and I'll submit
you
later,
can
my
show
lord.
it. It's up to you. If you
Yes,
do not give also, there is no problem.
For my lord's convenience, I will.
For you or for the court.
Paragraph 7, my lord. I'll take my lord directly to the paragraph 7. The TIP is concerned.
This is 1970.
1970.
Oh, that is not this. It is not included in your.
No, this is not included, my lord. Therefore, I've just brought it separately, my lord.
That is a known proposition of law.
My lord.
I don't think even the prosecution will dispute that.
My lord.
It cannot be. Now that is why this court had at the beginning asked you whether your conviction is based on the testimony paradigm. Once you pointed out that he was not present.
Yes.
Forget about for whatever reason he was absconding or whatever it is.
Yes,
but then the fact remains that he was never identified. During the stage of investigation, he was never identified.
Never identified.
Yes, what do you want to refer here?
My lord, paragraph 7, my lord.
Yes.
Now, may I just read, my lord, this little small paragraph, my lord. Now, facts which establish the identity of an accused person are relevant under Section 9 of the Indian Evidence Act. As a general rule, the substantive evidence of a witness is a statement made in court. The evidence of mere identification of the accused person at the trial for the first time is from its very nature
Exactly. That is where.
inherently very
For
weak.
the first time. Give
Yes.
emphasis to this.
Yes.
That is where.
Yes.
Now that means meaning thereby that no TIP takes place during investigation.
Yes.
And rather,
Ah.
as a substitute of that,
Yes.
the prosecution resort to this.
Yes. 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 So it's a very
Now, the thing is that this thing comes when the identity of a person remains in question.
Hmm.
Yes, for the first time in the court. Yes.
Yes, my lord. My lord,
So apart from this identification, which these two witnesses
Yes.
have done,
yes, my lord.
1 and 9.
Yes.
Oh, sorry, 2 and 9. Oh,
1 and 9.
1 and 9.
1 and 9, my lord.
There is no evidence against.
No evidence.
Nothing.
Nothing. So therefore, my lord, and my lord, even the court notes that TIP was not conducted against Louis. So my lord, I, on behalf of the accused, the convict rather, the appellant Louis Tudong, my lord, these are the points, my lord. And those judgments.
Whether this PW1 and PW9,
my lord.
their statement was recorded under 161.
Yes, 161. 161 was it?
No, you do not have to read it out.
My lord.
Because we cannot take, this is not admissible.
Once-
Until and unless
Yes.
a person is confronted with this.
Yes,
So
my
we are
lord.
not doing this.
Yes. 164, it is available in the report, my lord.
164, their 164 statement is there.
154 is there, my lord. But 164, my lord, again, if I read, my lord, there will be lots of contradictory statements are there, my lord.
But that is,
So that is a reason
that
why.
is good for you.
Yeah, that is a reason why I said, my lord, that this can I be convicted based on these two witnesses who are not reliable at all, fully unreliable.
What about their 164 statement?
164 statements, my lord.
You do not want to go through that.
My lord, I do not want to border, my lord. Why? Because again, the legibility comes, my lord, and then even a typepiece. That's why I did not want to. But my lord, the records are there, my lord. I can flag those, my lord. It's a very difficult case because of that is I think some kind of sort of directions, my lord, deserves from
You see, the
court.
prosecution witness is very cryptic here. Evidence is very cryptic. Equally, your cross-examination is also.
Yes, I bow down, my lord. I bow down, my lord. So the compilations, my lord, I will prepare according to the list. It is, of course,
better,
given.
and if you can give gist of your points. Huh?
Yes, my lord.
Do not make it lengthy.
No, my
Just
lord.
make it small.
I
Now,
just-
do you conclude your argument for this?
Yes, my lord.
So far as the oral version is concerned.
Yes, my lord.
When can you give your written notes?
Written notes, my lord, I can give it tomorrow itself, my lord. Of course, it is. I have already prepared my notes. I just need to put it.
No, you have to hear Mr.
Yes, yes.
Gurung also.
Yes,
And apparently he is eager to point out many things which you have not pointed out.
my lord.
You have left out reading all the evidences which you will do.
My lord.
That is what is expected.
My lord.
Plus 164 statement and
My
which you have.
My lord. And I would take my seat with liberty, my lord. If any rejoinder is necessary, my lord.
No,
my
no,
lord,
that is you will give a reply. A reply. What is it?
My lord.
We can always give a reply to these things.
My
So let us first see
My
what.
lord. My lord. All right.
And what about these decisions on the thing, interested witnesses and all?
I'm sorry.
Interested witness.
Oh yes, it is there in a part of the judgment, my lord.
Which judgment?
My
And
lord,
which paragraph? You have not mentioned your paragraph. Nothing is there.
that I was just talking to them. I'll make it properly and give
Then
it
you
to my
make a
lord.
proper
By
compilation.
tomorrow, I'll give it my lord, the relevance judgments. my lord.
Yes, Mr. Guru.
Let my friend provide the, my lord. That will be, I think, more.
No, that is okay, but then the thing is that so far as oral argument is concerned,
My lord, in that case, my lord, before I begin, my lord, I had thoroughly prepared this matter. I had even prepared my written argument and all. I even took the trouble of going home just now, my lord, to get that. Unfortunately, I couldn't trace it. But however, my lord,
No, this court will be definitely adjourned to some other day because Mr.
I'll
Yobin
satisfy
also
my
is-
lord here.
Yes, so you
Now-
do not want to address the court orally now, only after receipt of this you want to order.
I think that will be more effective, my lord, assistance, my lord. I don't want to spill the bean right now, my lord.
Mr. Yobin, what will be your argument in the next case?
My lord, all my submissions will cover whatever I have, except for the TIP part, my lord. The rest covers the same, my lord.
So the question of first identification will not arise in case of the second accused.
It will not arise, my lord. To that, my lord,
Was there anyone named in the FIR?
My lord, my lord, there's no specific, there's no name, my lord. There's no name in the FIR, my lord.
IO was not examined.
Was examined, my lord. Was examined, my lord. Was examined. And my lord, my humble
IO's deposition will not be relevant here.
will be, my lord. He has been examined as PW12, my lord.
Okay.
And nothing has come out in the cross also.
All right. No, since Mr. Yobin has not raised any grievance against that, so that is where this question is asked. Okay. What is the decision of the Apex Court with regard to eyewitness thing? Which one?
My lord, my lord, that will be Bhavani's case, my lord. State of Rajasthan versus Bhavani, 2003-7 SEC 291, my lord.
Again?
And what does it say?
This is about evidence of interested witnesses must be scrutinized with caution and requires corroboration.
So that is what. So that is just because of these things, this court was asking you on these things. Whether
Yes.
that the conviction based on the evidence of interested witness only
Yes.
is not valid in law.
Yes.
So you cannot say it is not valid. Only thing what law requires is that there has to be a careful scrutiny.
Careful scrutiny, my lord, yes.
See, criminal case, all the evidences needs to be careful scrutiny because it requires proof beyond reasonable doubt.
Yes, my lord.
When shall we give it? Next week?
Next Monday, if it's possible. Next.
Lots. We'll say just next week. That is better.
Next week,
Next
madam.
week possible. Just see anything.
So leave it.
Yeah, good.
Fifth,
my lord. April. My lord, the fifth and sixth is Monday, Tuesday. Monday, Tuesday.
So you can have it on Monday also.
Monday,
no
my
problem.
lord. My lord, so let it be.
In the meantime, my lord, advance copy maybe.
Let it be a part hard, my lord, and because
This will be. We will say that hearing has commenced. Would not be.
Yes, my lord, my lord. Then
So far, the first item is concerned. He has concluded his, my lord, argument. So it's my turn.
You want to shut him down right now? Huh?
My lord, that's what is stated, my lord. He has concluded so far. The first item is concerned.
if something comes out for the interest of justice, I'll have to argue, my lord.
We'll
No,
not
no
shut
bar.
him down. You see. Okay. This item. Both these items. So what is this item?
26.
Item
Yeah,
26,
yes.
my lord. Criminal Appeal 59.
Yes, yes. Though the hearing. Oh, just a Mr. Yubin, London Council for the appellant. Resumes his argument. comma, however, the same could not be concluded. Or rather, you just say hard learned counsel for the parties, appearing for the parties. Learning how learning counsel appearing for the parties at some length. Stop. The hearing could not be concluded. List again
On fifth.
so and so for further hearing.
My lord.
Meanwhile, it will be open for you to give written notes and all.
My lord, my lord.
But then do not prepare any lengthy argument and all those
My
things.
lord, I'll
And
just-
both the matters same order.
My lord, yes, my lord.
What is the supplementary paper book is about?
My lord, those two witnesses, 313 and PW6 depositions were left out on the last day.
313.
313.
Of this.
Yes, my lord. No? 313.
This witness also.
Yeah, PW6 and 313, my lord. Deposition of PW6 and examination.
Who is PW6?
PW6, my lord, is the MVI, my lord, is the MVI.
May not be much relevant.